May it please launch.
Last permission, ma'am. It is implicit.
May it please launch. The petitioner before your lordship's file, COP.
Where? Who appeared?
I am appearing.
Yes. We thought that video conferencing. Okay. Yes.
The
Which
petitioner.
case, madam? No
Item number
mentions
1.
today. Yes. Yes.
The petitioner before your lordship's filed COP commercial OP 239 of 17 under section 34 of Arbitration Control Act, questioning the award passed by the arbitrators.
Arbitration. Yes. Yes.
At the time, the case was entrusted to one Ravishankar Jandiala, who became a senior designate. Subsequently, he returned the files to the petitioner's company. The company entrusted the matter to some other advocate, Mohan Srinivas. And that advocate represented once before the commercial court. Subsequently, he did not represent it, due to which the petition was dismissed for default. When the respondents filed the execution petition and when the petitioner received the notices in EP, they contacted the other advocate, Mohan Srinivas, about the case.
All right. Yes, madam.
So, condoned petition was dismissed against
Fine,
which
fine. Heard on the. Nobody is appearing. Heard on IA.
Hearing for respondent number 1, my lords.
Yes, madam.
My
What do you
lords,
say?
no prima facie case has been established.
That is correct, but you know what is Supreme Court has said about expression sufficient cause.
No insufficient cause has been established.
That is your submission. So if you want, we will pass an order today itself, or we keep it pending for 5 years. Choice is yours.
My lords, I'll finish my submissions. I'll make my submission.
Please.
My lords, the designation of the counsel for the appellant.
No, 1 minute. Give us dates. She has not told. When when petition under section 34 was filed, date. No idea. When it was dismissed for default.
31st March 2022, my lords.
22.
20.
Yes, ma'am.
Then when did you, how did you know, according to you, that
After
it has been
receiving
dismissed for default?
After receiving the notice under CEP 31 of 22.
Notice of execution proceeding 31 of
31/3/22 is the dismissal order. And we came to know.
We asked you, when did you receive notice of execution?
22/11/22.
22/11/22.
Yes.
What is, you told something execution case number also. We
Yes,
were
my lord.
stuck at
CEP number 31 of 22.
CE. What CE?
Commercial execution petition.
Number?
31 of 2022.
Then when did you file the application for restoration?
30/11/22.
How can this be? When you received the notice of execution?
On 22/11/22, we received notice.
Then how can you file before that, 13/11/22?
30 after 22/11, 30/11/22.
Filed application
3C.
seeking condonation of delay, seeking restoration and
220.
condonation of delay,
Yes,
212 days.
212 days.
So what is your explanation? Number 1.
From the actual date of dismiss for default order was not informed to us. It's not known to us till we received the notice. So, Lord, actually from the date of.
Why it was dismissed? Your counsel did not appear.
That's what, Lord. Earlier advocate is Ravishankar Jandiala, Sir Ravishankar Jandiala. He became senior designate.
So he got
He
exempted.
returned the file.
No. So he got exempted from requirement
Yes.
of appearing before courts.
Yes.
So that's why he didn't appear.
So he returned the files to the company. and the petitioner company entrusted the matter to another advocate, Mr. Mohan Srinivas. Mr. Mohan Srinivas represented once and informed the company the next day. So the,
When once represented, once is important. When he
Yes.
appeared,
in the order,
what is the award, madam, against her, him, against the petitioners? Award, appellants. Award,
award is 3 crores and all.
3 crores.
One. Yes, right. Negotiated seek revision. So madam, yes, we should not waste time. She is not ready. You go ahead.
My lords, the case is about dismissal of condoned delay pending.
We understood this. That's why we have noted all this quickly. Your submissions, madam. 2 minutes.
Okay. Designation of the senior counsel cannot be taken as an excuse, my lords. And the advocate that they are claiming, like Mohan Srinivas, he himself represented before the trial court that he has never received any no objection wakalat from the petitioners. It is a clear case of intentional negligence, my lords. There is no sufficient cause.
No, correct. Very well. This is what it is. Yes. Yes. So madam, we asked you something. You were turning pages. When Mr. Mohan Srinivas appeared once, and what did he tell you next day? That version is still missing. That means
One more submission. Mr. Ravi Shankar, who is claiming to be the counsel for the appellants, was designated as the senior counsel by this honorable court by notification dated 17th April 2021. And the suit was dismissed on 31st March 2022. They had nearly 1 year to engage an advocate. It is a case of intentional negligence.
yes. They filed the petition under section 34, deliberately wanted it to be dismissed, according to you.
It is
Fine.
dilated act.
Yes.
Not
Okay.
the
Madam.
statement we have made in the petition.
No. So when he once appeared, then he told you what? That sentence is incomplete. Once appeared and told you what?
Here, my lord, in the petition amendments, we have mentioned. It is stated that petition was dismissed so and so, as there was no representation to the petitioner on 2/3/21 onwards. Only on one occasion, it was represented that another advocate will file wakalat, and the advocate did not file the wakalat. Lord, as far as the author is concerned, Lord,
See.
in the
Madam, condonation delay, you take this much of time. Tell us the date. What did Mr. Mohan Srinivas told you? Tell us. You are reading.
Mohan Srinivas informed that
Once appeared and then
only I appeared. Subsequently, I did not file wakalat.
Why he didn't file wakalat? Because you did not give wakalat.
Lord, when he was asked to represent, it is obvious that wakalat will be sent to him. Without wakalat, how he could represent on one occasion also? That itself shows that.
Bar Council has the answer. Bar Council. Go to Bar Council. That has the answer. How? Don't ask us questions. We are not sitting here
Sorry,
to answer. No. We are not sitting here to answer your queries. We are sitting here to decide your appeal.
That's true. I'm not asking the
How did he
question.
appear? Don't tell me.
No.
Behave.
I'm sorry.
You should have brought the case law which you did not bring and arguing everything else. That a fault committed by a council party cannot be penalized. Except that you are this thing. You are also an advocate, madam. In some other case, the company will make a similar statement against you also. Always remember, don't encourage clients to make statement against the advocates. And how did he appear? You ask him, he is your colleague. Ask him, how did he appear? Ask us. That is not the question which arises for consideration. That is all the more ground for dismissal of your appeal. That he appeared and thereafter did not appear. And you are unable to explain why he didn't appear. This appeal.
The fact that
This
he
appeal.
appeared once.
All right. Cost. So delay is condoned subject to payment of 1 lakh as cost. This appeal under section 13 within bracket 1.
The appellants are the petitioners for that.
Yes.
Yeah.
All right. Third, on the question of admission, learned counsel for the appellant submits that the learned single judge. Notice, you don't want notice to be issued.
Respondents are appearing, my lord. Respondents are
I'm
here.
appealing for R3 to R7.
Accept notice.
Respondents are here, my lord. Can be disposed of.
I'll file a
No,
count.
no, not without this thing, Mr. Not without the synopsis and all that. Don't, if you want disposal, it not, doesn't mean that for next half an hour, you will tell us this happened, then mutation, then RDO passed this order, then did this. If you want disposal, please give a synopsis. This is motion hearing, right? It's not final hearing. And this is 23 appeal.
But urgency is there for that reason.
No urgency.
No, just do. I am not arguing on the merits of the case, my lord. Only I am aggrieved about, my lord, the order of the land.
What is the stay you want? What will happen if stay is not granted?
My lord, construction activities is going on. Construction started.
It's more of a consent order.
So what it amounts to, still the construction. Only with regard to, my lord, granting of the status quo order, my lord, till the disposal of, my lord, the matter by the district
Yes,
collector.
Mr.
Mayor. So it's an order which was.
No, you tell us you had filed a suit seeking the relief of permanent injunction. You had filed a suit seeking the relief of permanent injunction in that, listen to us.
That was not part of the
No,
record.
please.
That was not
please.
part of. I'm making my submissions.
No,
That-
please listen to the query, then answer.
No,
We are here to,
No, I've understood that.
But-
That's the reason.
understood?
Yes.
Fine, it's so fast, right? Then answer. If
The
you have
suit was
understood.
filed. So we'll see the suit was.
We want everybody to follow without asking questions. He knows what the question is going to be asked.
That's
Yeah,
what.
please,
what-
please.
The suit, this was not part of the original writ petition which was filed before the learned single judge. It was now in the grounds of appeal, they have taken up an objection saying that even at the time of arguing the matter, nothing has been canvassed so far as the court does not speak about it.
And it's not a fact that you filed a suit.
Yeah, we filed a suit. We filed
In
it.
that order of your application for injunction was rejected in the year 2017.
Yes.
How this,
No, no.
this can be injunction in your favor can be
but-
granted in a rate petition.
Sir, Lordship will see. Sir, we filed an application IN number 1380 of 2021. The order was there up till 6/7/2022. 6/7/2022, the order was continuing. Status quo injunction order was continuing, not to make any further change of the nature of the property was continuing.
No. He is only aggrieved by injunction status
That's
of
what-
part that this can take place. The remand and all that.
No, what's the? I mean,
No. If your suit is pending, file a application
no,
for injunction.
If I make my submission, then I'll stop for that.
Fine, yes.
Lordship will see. So the injunction order which my friend has stated that was vacated on 6/7/2022.
When it was granted?
It was granted on 27/12/2021. 27/12.
27/12?
Yes. It was vacated on 6/7/2000.
Which year? 17?
No, 2021.
21.
Yes.
It
was vacated on 6/7/2022.
No, we are asking about your application for injunction, what happened, which was filed in civil suit. Date of.
No, the 2021, the application was filed. 2021.
In the civil suit.
Yeah, in the civil suit.
Suit of 2017, you filed an
No. IN, that's 1380 of 2021.
respondent 3 to 7, you are appearing.
Yes.
Your injunction petition was dismissed before the trial court.
Right.
When was that?
That's the date I'm furnished, 27/12/2021.
27/12. All right.
Lordship, I just look at the
So what is OS number, Mr.? OS number
126 of 2021, sir.
126
Yes.
of
2021.
ah,
This dismissed on 6th day of July 2022.
all right.
The order was continuing till the date of the passing
No,
dismissal.
no, 6 July. You
6
said
July
17, 12,
2022.
21, it was rejected.
Yes.
Then
22, it was rejected. I had,
it was granted on 17 to 21
yes.
and vacated on 6, 7, 12,
Yes.
22.
For 1 year, I had an injunction order in my
Yes.
favor. Ultimately, it was vacated on 6th July 2022. Maybe when there was a, he preferred in directly went to 227 and High Court. High Court said, then Supreme Court said, hey, file the CMA and all. That was that's interim period. That's what the
So order of vacation of stay has been injunction has been upheld by Supreme Court.
6th July 2022.
This order has been upheld by Supreme Court office.
Sir, we
You
wrongly
said went High
no,
Court and Supreme.
we wrongly excised the jurisdiction by directly filing in a 227. Then the High Court said that go before it file the CMA. That is not part of the record.
Only for 6 months. No, but he filed a suit for injunction. Then he's saying directly filed a petition. What, where? You said that suit, you filed what we have understood. I mean,
No, I'm not
we are telling you. We are
not
telling you what we have understood.
Yes.
That's the problem of not listening to judges,
No,
right?
this-
Because what we write matters, what you
Yeah,
say
I
doesn't.
understand.
So what we have understood is that you responded 3 to 7 filed a suit. In the suit, an application for injunction was filed. That injunction was granted on 17/12/21 and was vacated on 6/7/2022. Right? So thereafter, what happened? We didn't get anything. You said original jurisdiction, Supreme Court, we didn't get it.
Against this order, we would have filed a,
So which order?
this is the impugned order dated 6th July 2022. We could have filed a CMA. The party engaged some other advocate. They filed 227 before the Honorable High Court. I don't have right now the number and all, but so far as I know,
Fine.
then ultimately High Court said because the right of appeal is provided in 43(1)(r).
Yeah, yes, of course. No, who will entertain, you know?
Before the appeal.
You did not even then
No,
it went to Supreme Court, that was also upheld.
Ultimately, Supreme Court granted time to the client to prefer a CMA confirming the order of the High Court. That is the what the state interim period was what I'm
Yes.
saying.
So what is your submission?
No, now submission would be, sir, basically when the matter was, this is the record which now has come up before the writ appeal, saying that this is the order passed. When the order was passed by the single judge, nothing was pointed out. The order which was not part of the record can be said to be relied on a writ appeal, basically. Writ appeal.
No, but are you disputing this fact?
No, I'm not
Can be,
Sir, because first time the grounds, Lordship, see, first there are certain procedures. If you want to rely on a document, file an application, sir, bring it to the notice of the single judge. Never file an application.
you filed, Mr. An application, production of document and let us see how he denies it.
Just one.
That's only an adjournment, right? Nothing changes, Mr. You understand.
I understand.
You have argued it very well. We thought that you are a reasonable person, but you are insisting on hyper technicalities.
No,
You will file an affidavit, you deny that this order is not passed. Deny. We will determine the scope of taking note of the events by way of an application. If you want us to write an order on that, I will write it.
But I think Lordship, I see.
While order is
what I
is
said.
arguing that the injunction order is not part and parcel of the reputation record.
You place
So this is subsequent event. My reputation is 2017.
So therefore you should have brought it. You filed it day after.
But we will not know there was no indication at the time of disposal of the reputation by the land single judge. Or they have argued it saying that they wanted a status quo order. That is the case where they would have brought it to the notice of the land single judge. 3 months.
Just listen, what the honorable chief justice.
I understood, my lord.
You file the petition with the document, we will see how this, that would be denied, that's all.
He is admitting, but despite that, his technical point that
Ah,
he
yeah.
cannot take note of not there.
Himself is court.
Admitting. So we will record this submission.
Sorry.
No need to get agitated. You are the landowner. You are a council, right? We also don't own the land. So by allowing your appeal, we are not going to get the land. None of you nor both of us.
Sir.
That we assure. Don't get agitated.
He himself suppressed the fact, my lord. If you don't get to the notice of the land single.
You want to file or don't want? Then we will deal with it.
Affidavit,
Huh?
affidavit has to be filed, sir.
Also file, you file along with this thing.
I will file an affidavit.
All right. Learned counsel for the applicant.
Documents are there before your lordship, my lord.
No, petition to receive,
Because in the medical plans now we have.
petition to receive additional documents in writ appeal,
So, permission to file additional documents. Understand?
that you file.
Day after tomorrow, not because this is there.
We are giving you day after tomorrow.
Yes.
But
Saying
please permit us to dictate the order. If you keep on doing like this, 1:30 will be over. Huh? This intra-court appeal has. We should be ready with this law on 4127, right?
Settled law, settled law.
Very nice.
What is subsequent event to be brought on record to enable
This
this
much-
parties to rebut it.
You should each one of us has sufficient experience, you know. And I mean that still you want us to write cases on 21/7. What are the powers of appellate court receiving evidence?
Because
Your only contention is that it's not a subsequent event, right?
it was not part of the record. That's the reason now. When both the
So then Friday you will take time to file counter.
parties, that's the reason lodge my post on Monday. Meanwhile, let them
then
serve-
meanwhile, we will stay the direction.
Otherwise,
Yeah.
lodge my post on Friday, then we'll.
No. We don't want time. You take time.
No, I don't have to take time. I'll straight,
Take time.
I'll straight away make
We
this.
are, no hurry, we are staying the direction.
I leave. What I, we, Friday will argue
Just
the
one
matters.
minute, 1 minute. We'll stay. However, learned counsel for the
May I please your lordship? May,
spot number 6.
may I please? I am for the petitioner, your lordship. May-
Then you should argue, right? He's saying this. You want to argue his case, please go ahead. Go, that's why. Even before he could tell us that I am appearing, you are saying for R8. Caveat. Let him, it's his appeal. We are not passing any order of stay against you.
May I please your lordship?
He was asking.
Why have we not made the state election commission a party? They are the people who.
Your lordship, initially, my lord, the OP was filed, my lord, by the respondent, 6th respondent, my lord, without making that.
That's what I am saying, is state election commission a necessary party? For them to, they are the people who conduct the election,
Yes, your lordship.
they are the necessary parties or not?
But they initially, my lord, they could not take that, your lordship, may I?
Non-joiner of necessary parties.
But that initially, the 6th respondent filed election petition, my lord. That has been, may I please your lordship? In this matter,
So
lord,
what does rule 8.3 of election rules
Yes.
provide? Where is that?
that rule 8.3, your lordship, kindly see Panchayat Raj.
No, you tell us what does it provide? And if you
Your lordship,
fill in the, no, you
Yes, bro.
leave everything blank, don't disclose
No.
anything about your criminal antecedents.
your
Still
lordship,
you are entitled to continue and nobody can touch you.
your lordship, kindly see, my lord.
Tell us.
Just kindly see page number 139, your lord. My nomination papers, your lordship, kind enough to see that. 139, your lordship, kindly see.
So first tell us the rule, then we will go to
Your
what is the
lordship, he has to
requirement.
submit, my lord.
Two things we want to know, mister. We must please listen to judges so that we have been telling.
I'm sorry.
So what is rule 8.3? What are the consequences of non-compliance of rule 8.3?
Yes.
In the rules, you tell us and then we will see your nomination paper, order, everything.
Yes,
Where is rule 8.3?
yes, your lord. Kindly see, my lord, Panchayat Raj.
Yes. What
Your lordship, I think, page number 273.
this book,
Yes, my lord, that is.
this book,
Yes.
your book is different.
May I read that for your lordship convenience? That's rule
Conduct
8.
of election rules only, no?
Yes, my lord, that is.
Telangana Panchayat Raj conduct of election rules.
Telangana Panchayat Conduct of Election Rules 2018, your lordship. GOMS number 28, your lordship.
This book, page.
Your lordship. Your lordship.
72.
Got it, your lordship. Your lordship, may kindly see, my lord, rule 8.3, my lord. Every candidate shall, along with the nomination paper, also file a declaration along with regard to his criminal and state assets and liability and education qualification as required by the State Election Commission in the prescribed format attested by two witnesses. This is the,
Pursuant to this. Yes.
this is the requirement to be followed, Milord, while filing the
What
nomination.
happens if it is
Your
not complied with?
Yes, Your Lordship, kind enough says, see, page
No,
number.
we are asking, Mr. As a counsel, forget about the facts. As an officer of the court, that some candidate files a nomination paper, doesn't file a declaration. What happens?
Your Lordship, kindly, that's why he has filed.
Consequence.
Yes, Milord.
Forget about facts. We are asking you generally, then
Yes.
we come to facts.
That has, this is this has returning officer has to make it corrected, Milord, at the initial threshold itself, Your Lordship, kindly. His nomination.
No. Supposing if he doesn't file a declaration, what happens to his nomination form? It will be accepted.
It will not be accepted, Milord. It has-
Where is that provided, not accepted? That's what we are asking you.
Your Lord, that's why, Milord, he has filed declaration also, Milord.
He may have filed in this case. We are asking generally, Mr.
Yes, Milord, it is an improper nomination.
You
It
don't
has to be-
understand. You don't understand the query. Why these are local rules? That's why we are asking you to ascertain whether it is mandatory or directory. If the consequence is provided in the rule itself, it's a mandatory provision,
It is
not provided.
It is.
Who will tell us, Mr. GP? Where is, he is not aware what happens if a nomination form with this thing, nomination paper along with declaration is not filed. Where does it provide that this such a nomination paper not accompanied by declaration has to be rejected? There must be judgments of this court saying that either this provision is mandatory or directory. We are sure that this is not this controversy has not arisen before us for the first time. The consequence should provide. Where is the consequence, Mr.? You don't know, right, Mr.? Better prepare.
You lost to kindly for a moment, not that.
You don't know answer the question. That means you have not prepared the case.
You lost to
We are asking, supposing if a candidate files the nomination paper, does not furnish the declaration, what happens?
It is treated as an incomplete
Where
nomination.
is that?
That has been, Milord,
Where is that? Any case law?
case law is there, Milord, that is.
What is it?
This is the 2000.
Mr. Now you sit down. You argue now. You wanted to argue. Sit down. Yes, your case will be argued by him. So, Rule 8.3. Read Rule 8.3.
There is a circular, a government matter, lecture 4 is there. Is a mandatory for the rules first.
No. In the rules, anywhere it is provided that the nomination
Yes.
paper will be rejected
But there
if it is not accompanied by declaration. Where is that? Which rule?
Election was issued by the government matter for the election rules. There is an order of the government of Telangana saying that matter these rules.
Which page? Order of Telangana.
It was not available, but matter is.
Mr. Consequences of non-compliance cannot be of a rule. We have our own doubt whether it can be provided by government.
And in at least you get this matter.
No, we are asking you a question whether the Rule 8.3 is directory or mandatory.
It is a mandatory.
How? The consequence of non-compliance is not provided in the rule.
Can I read this?
No.
Of the government matter regarding this rule?
Do you understand?
Yes.
Consequence of non-compliance of the rule has to be provided in the rule itself, not by government order.
I will check it and I will please propose tomorrow matter.
Your Lordship,
Now,
I kindly,
so
page number 218, my Lord.
you wanted to argue, not ready. Learn it.
Yes,
He-
I was trying
No, therefore,
to show them my identity. I was present.
no, but you should be ready.
I-
No, you should be ready. Ready with the matter. Not only show identity, but be ready also. Your identity will be There is the order sheet, mark the presence. When a query was put to learned counsel for the parties,
Your lordship may kindly,
better prepare, Mr. Otherwise, we will then again, you will have to answer. We are sure that
Yes,
you
my
are,
lord. Grounds
are you ready?
grounds of rejection of
No, no.
nomination.
Are you ready?
Provision. We are asking which provision.
It's a Supreme Court judgment, my lord, is a date of,
Where is declaration? Where? So it's amended to. Mr. David, you don't know what? So,
Kindly see, my lord, page number 140, self-declaration he has given, my lord. This is, it contains not a self-declaration itself, your lordship, kindly. May, it is in Telugu, but either page number 146, my lord. That is my nomination, which has been accepted, my lord. But page number 139. Your lord, page number 139, you lost my kindly, similar. That is in pursuance of election rules, my lord. TSHC election rules, you lost my kindly, similar. It is.
so this is your nomination paper,
Yes,
right?
your lordship. In that, it is self-contained declaration itself, my lord. It is,
Nomination paper.
yes, my lord, it is a self-declaration form. It is amounts
So
to,
no criminal case pending against.
yes, your lordship, no.
Where
Your lordship, kindly, similar, I would take.
Where have you said, where is the column? Tell us.
May kindly please similar, the ప్రమాణ పూర్వకంగా ఇంక తెలిపిన వివరాలు అందజేయుచున్నాను. ఈస్ మేకింగ్ ఎ ఓత్ ఆన్ మిలట్.
Which
అవసరం లేదు, ది ఫస్ట్ పేపర్ ఇట్ సెల్ఫ్ మిలట్. అవసరం లేనివి కొట్టివేయండి. దిస్ విల్ స్ట్రైక్ అవుట్ ది విచ్ ఇస్ ది పోర్షన్ విచ్ ఇస్ నాట్ అప్లికబుల్ టు యూ మిలట్. యువర్ మే కైండ్లీ సీ హి హస్ పుట్ ఆల్ ది మిలట్ డాష్ and strike out milat which are not applicable to him. He is not facing any criminal cases.
Criminal case not
No criminal
applicable
case.
to you, you are above law.
No, milat, he has not facing.
Lighter when, mister, we are saying, why are you so serious? There can't be any criminal case against
Yes, Lord.
Sarpanch.
Yes, milat.
The moment you file nomination paper, all criminal cases, if pending, disappear.
Yes, not even they are there is no.
When did you file the nomination paper, mister?
Yes, not
Date. Which column you said nil?
even in even in
Column, 1 second.
fourth one
Criminal antecedents. where?
Criminal antecedents, which part?
140 page number 140 milat column number 4.
He is required.
కోర్టు ద్వారా శిక్ష పడినటువంటి నాపై గల క్రిమినల్ కేసు వివరం. He has made it strike down milat. It's
No, there's no question of striking down, mister. Rule 8.3 you have read.
The nomination form itself is.
Listen to us. What does Rule 8.3 say? Along with the nomination form, you will file a declaration.
Yes, my lord, this is self-consent declaration, my lord.
Ah.
It is your lordship, that's why, my lord, kindly see the
Declaration. That
Yes,
criminal antecedents.
ఇతర సాక్షుల సహకారంతో స్వయం ప్రకట సెల్ఫ్ డిక్లరేషన్. ఇట్ ఈస్
Where self-declaration?
దట్ ఈస్ 146 your lordship.
English translation is 148.
148 your lordship. The above declaration hereby solemnly affirmed before me so and so and so. It is a self-contained declaration, no separate declaration required, my lord.
So why your nomination paper, why the election petition has been allowed?
Yes, my lord, your lordship kindly similar. In the nomination form itself, my lord, they have mandated that, my lord, which column is not applicable, you make it strike it out. My lord, he is not an educated person. He made a strike down, my lord. Only education column, my lord.
No criminal cases pending.
No, as on today, no criminal case. It's
No,
not.
that means as on date of filing of
Yes,
nomination.
my lord. As even as today also, there is no criminal case against
Pending.
him.
All right.
You lost my
So
kindly.
election petition has been allowed only on the ground that
Yes.
you did. Listen,
I'm sorry.
Huh?
I'm sorry.
when we ask you questions, you don't know. And when we want to tell, then you
I'm
want to
extremely
speak.
sorry.
So this thing, as we understand correctly, the election petition against you has been allowed only on the ground that along with the nomination form, you did not furnish a declaration, correct?
Yes, ma'am. Yes, ma'am.
Correct.
That's
And that order has been upheld by, that is the order under challenge.
yes, Lord.
And that order has been upheld by Learned Single.
Single judgment.
Correct.
6 issues there, 4 were held in this way, 2 were rejected. And those 2 were that we didn't fill up this case. So, columns in your form. We didn't fill any column vacancy. If you want to say something, you could say yes or no. No, but see, he did not say anything. He has put all dashes. He did not say, is there a criminal case? He did not say yes, no. He simply put a dash. By putting a dash, what does it mean? Now go to page 146. You are saying it's a self-declaration.
Yes,
Please read 146 column under the Gamanika, class 2. Class 2. Read now. You have 146 page?
Yes, Lord.
Now Gamanika unda kinda, there is a Gamanika.
Gamanika,
Please read column class 2 there.
Yes, వారంలో అన్ని గడులను పూరించాలి. ఏ గడి ఖాళీగా వదిలివేక. ఏ అంశం గురించి అయినా తెలియజేయటువంటి సమాచారం లేనప్పుడు సందర్భం బట్టి ఏమీ లేదు లేదా వర్తించదు అని తెలియజేయాల్సి ఉంటుంది. You will ask me kindly similar. If ఇది 139 kindly similar. రాజకీయ పార్టీ తరఫున స్వతంత్ర అభ్యర్థిగా పోటీ చేయుచున్నాను. అవసరం లేనిది కొట్టివేయండి. You will ask me kindly, my lord. He understood that, my lord, he has made a strike.
Where are you reading 139?
Yes, my lord, 139, my lord. ప్రమాణ పూర్వకంగా ఈ క్రింద తెలిపిన వివరాలు అందజేయుచున్నాను. నేను రాజకీయ పార్టీ తరఫున స్వతంత్ర అభ్యర్థిగా పోటీ చేయుచున్నాను. అవసరం లేనివి కొట్టివేయము. You will ask me in pursuance of that, my lord, he is put to, my lord, strike out whichever not applicable to him, my lord. This is the
declaration. This declaration at page 146 is part of the form or not?
yes, my lord.
So you have to be, it is to be presumed that you have read and understood all the columns correctly.
Yes.
And the terms and conditions correctly and are making a declaration.
Yes, your lord. That you are, I mean, in pursuance of that, not he has.
Nowadays, he is a young man, aged about 28 years, and you are saying illiterate. It doesn't exist now, illiteracy.
You will ask me, he is a servant of that. He is first time contesting, my lord. He belongs to
illiterate means what is this thing? What is his educational qualification?
Education model is 8th
You
class.
said illiterate. 8th person is not.
He is uneducated. I am not saying that it is not highly qualified.
You said illiterate.
It is not a lapse mode. He is not facing any criminal accident. Not education qualification according to their own millet judgments. Not it is not. It is an optional education.
Name of India Democrat, that is 2002. In fact, that is what
Only 4 months left. Milord is in tenure. Milord, the budget.
The term is getting over.
Yes,
He is
sir,
lucky
only
enough to enjoy the 4.5 years term.
No, Milord.
In fact, the repetition is before us
When
for holding elections.
when were you elected as Sarpanch?
Near Milord in the year 2018. Milord.
19 January.
19 January. Milord, he will come.
7th to 2nd of February were the elections.
Only 4 months. Now the bills and all.
When your tenure will come to an end?
Within 4 months, span of 4 months, 2024 Milord, January, the elections will be to be conducted. Now all the bills not pending and he has to complete the worst note in the medal. This is the
No. What is?
Here it says strike out. Here it says. Yes, sir. That will be in the form and the declaration. It is simple. Here this is the form. Here it says I I'm not contesting, I'm contesting on behalf of any political party or independent. Hmm? So when it says this bracketed portion, it says also in many particular means strike off, whichever is not applicable. So we said it is all not applicable, therefore I have struck out. While here it says that's a very criminal case, we can here. We need to criminal cases, and these are cases we have more than that. This declaration says yes, sir. If there is no information to be provided in the columns, you should write whether nothing is something is available or not applicable or applicable. Yes.
Ah, Mr. Yes, what do you say?
Mr. Mukit, short issue, I'll put it because the form is in Telugu. I've just, there is a contradiction between the form and the declaration. That is the only issue which we need to consider. Do you agree that there is a contradiction between what is said in the form and in the declaration?
As well as the fact that no criminal case is pending against him. So therefore, there was no this thing of intention of suppression of anything. So what, Mr. Please see what you before you will have to be told, page 139. 139, this portion come.
Please read that 139, 1, where it says Kotti Veyavalani, strike off. And the declaration says, you answer, Emi Ledu Ledu, Vartinchadu.
No, 139.
Please look at,
Elaborate answer.
no, please look at 139 and tell her there is a contradiction between,
Serve the pages.
you are not served with the paper.
Then, sir, fine.
To, to MPC.
Mark the presence, learned counsel, mark the presence, learned counsel for the appellant submits. No, heard on the question of admission. So we have to write, we can't say that he did not state any facts. For our sake, we are writing. Appellant and respondent number 6 contested the election These are local rules. That's why we are asking. That doesn't mean that, no, that doesn't mean if we ask we can't find out. Rule 11 is the answer. Rule 11, 1, 2, 4. It's not a teaching class going on. Forget about it. You wanted to say something in view of his submissions. We are not asking you that question now because we have the answer. All of you did not answer. You were seeking adjournment for tomorrow. Yes. So, Mr. So and so, you are what? Sixth respondent on has advance notice has appeared. But how can you oppose admission of a case? Yes, so what submission? Why it should be dismissed? Criminal case pending against him? Against appellant? Is it pending in your knowledge? You are his opponent.
Yes, sir.
Criminal case pending?
You have
no knowledge.
139 kind of number 139.
Make submission. What is it? 139. We will see. But please tell us why you are referring to 139 first. So
Where the honorable court was to see
This is the form for Sarpanch or not?
it is not for that.
that say so. Say so. This is not. So which post Sarpanch? If not Sarpanch, then which? Did you challenge his election petition, the election on the ground that he did not even file the nomination form for the post of Sarpanch?
Not fulfilling the.
No,
This is-
Mr. Mukid, you said the 139 is not the form for Sarpanch. That is why we are asking this question. Why is it
You-
not for Sarpanch? It
Did
is
you
as I can
Did
read.
you take the ground in the election petition that this?
The separate rules, my lord, was the.
No, did you take the ground in election petition that he did not fill the form for the post of Sarpanch? Learned Counsel for respondent number 6, paragraph submits that the
Yeah, taken.
Your Lordship kindly similar. The order is passed only 1 week back, my lord. Your Lordship kindly no notice is given,
no. Has he taken charge?
No, my lord, I am not aware of this. Your Lordship kindly.
Question I asked is, election commission, state
30
election
days.
commission would be necessary party to tell.
Taken charge, my lord. 7th of August.
All right. What can be done?
Your Lordship kindly similar.
We will decide this issue. Interim relief does not survive. Learned Counsel for then this should have been the first point. I appear for R6. First point, sir. Charge. This is the order which I am. First sentence. Then we are not interested in your apology, Mister. This could have been saved. Time could have been saved. That's what Learned Counsel for respondent number 6 submits that. Notice. Third on the question of admission, petition is admitted for hearing. Notice. Whosoever accepts
I'm a first respondent, my lord, services 3, second respondent.
Except one and
I
two,
take
right?
notice for respondents 3 and
3 and 4.
state of Andhra Pradesh.
Service is complete. 4 weeks time to file counter.
Both matters are connected, my lord.
LTC.
Only.
5 and 6.
Stay.
When
Yesterday,
petition is
yesterday.
admitted for hearing, let
Yes.
the same be listed for
Clear?
21192 of
That's a clear stay may be granted against the admission to MBBS,
not
MBBS,
grant, we will not grant stay.
because
What is the order passed in your case? Yesterday you had appeared,
yes,
right?
yes, appeared.
What was the order
Stay,
passed?
stay language is not there. Stay against the admission process in the order.
What is the order? Can we pass a different order today?
Till the outcome of this, this writ petition.
What was, Mr. asking you a straight question. Either
That's it.
you, please feel free to tell that I have not understood the question posed by the,
Lordship.
put by the court, then we will repeat. You did not understand what other interim order was passed in your petition yesterday. We are asking you. You say that I don't know.
I heard that till the outcome of this writ.
Any admission heard on IA number so and so, any admission made against the seats under NCC A and B quota in MBBS
Admission process should be stayed, the only request. Because they'll.
So you want us to reject it, right? Learned counsel for the petitioner submits.
That's it.
Right, heard on IA number 1 of
That's
2023.
it.
Give that
That's
file.
not, sorry.
Heard on IA number 1 of 2023.
That's-
Learned counsel for the petitioner submits that the process of admission to MBBS stroke BDS course in its entirety be stayed. Paragraph. We have considered the two thoughts, correct?
Not my intention, Lord.
That's, we get it.
And how many?
There is a-
The Honorable Supreme Court said admission process cannot be stalled.
There is limit to being unreasonable. Limit. Yesterday you have argued. You should have said that, sir, don't, this thing, I have filed SLP or I am filing SLP against the order passed yesterday. We, in your presence, we said admission shall be subject to, you accepted that. And despite that, you are arguing.
Only.
It's not that any other council is arguing who may not be aware.
True. Yes, sir.
We remember you, Mr. Zulfikar Alam.
Yes, sir.
We'll remember you. Yes. Next. How these people, Madam, appeal order under section 14, appeal lies under section 17, Surface Act. We have held, no? This is an order under 14 of Surface Act.
Yes, my lord.
Appeal lies under section 17.
Lordship, there is Supreme Court judgment I have filed along with the expedition. Lordship, there are 20 to kindly see that. It is,
No, we also want you to see that we have taken
there,
view
there,
against an order under section 14 and appeal lies under section 17.
apart from that, the information, required information was not given. It is-
We have held, madam, against an order. This is not, this is Surface. Surface 1347 against an order under section 14, passed under section 14, not 13.4. 14 appeal lies. We have referred to Supreme Court decision. They are relying on 2012 matter, old case which has been overruled.
You are relying on that.
Yes.
It has been,
No, you are relying on government.
that has been overruled, Mr. Citing an overruled judgment not fair. Misconduct, Supreme Court has said.
Last my kindly consider,
Yeah.
apart from that, the relevant material, these persons, the wife of the deceased, the guarantor, my lord, and such.
So,
He had been requesting the bank authorities to furnish the information. They are not furnishing. He paid after issuing notice.
1 minute. You have in this petition, you have challenged the order dated 23/5/2023 passed under section 14 of the Surface Act. So now you are telling us the grounds of challenge. Just tell us why an alternative remedy of appeal you should not resort to under section 17 in view of judgment of Supreme Court.
That apart from,
No, apart from, first answer that and then challenge on merits.
I am submitting, my lord. I am leaving a point, my lord. I am raising one more point, Lord, kindly consider that aspect.
No, appeal lies.
Yes, my lord, even appeal lies, alternative remedy is there, my lord. When the principles of natural justice are violated.
That is understandable. Whirlpool, not that difficult, mister. So order has been passed. Just a minute. Order has been passed without affording an opportunity of hearing to you.
That apart, my lord, the bank authority is also not furnishing the information. The bank authorities he filed under Right to Information Act. Also he made, they are saying that his personal, 81 is under section 81 of the Information Act, it cannot be provided. So the documents pertaining to the father of the husband and father of the petitioner's my lord, they are not furnishing instead of making representation on the Right to Information Act. If that is furnished,
That is not the subject matter of this appeal.
I have raised, my lord. I have raised that ground, my lord.
No, sir. Mister, one sentence would have been enough that though an alternative remedy under section 17 applies, but my case falls within the exception carved out by Whirlpool because order has been passed without affording an opportunity of hearing to me. Good enough.
That not only that order, my lord.
You are saying something under Right to Information Act, which is that order under challenge under Right to Information. So that's a different cause of action.
I am questioning the action of the bank authorities also, my lord. Not for providing.
If you are aggrieved by non-furnishing of information, you have a grievance under Right to Information Act and separate. You cannot link two causes of action.
My respectful submission is that even for making appeal, my lord,
Shyam Sundar Agarwal versus Central Bank of India appeal lies.
yes, ma'am.
14.
My interest may be protected. I will make appeal to the authorities in the meanwhile not to take word. I have paid 24 lakhs of preference sale notice, my lord. After that payment of that, this order was passed. My lord.
Which order?
May please, my lord, exhibit P5 may, exhibit P5.
Ah,
Clear.
Mr.
I am for the
He is,
respondent.
just a minute. He is agreeing that he will take recourse to the remedy of appeal till he files an appeal and his application for stay is considered. Don't take action. He has paid the amount of 84 lakhs.
That,
Correct?
that is accounted, my lord.
Apart
Is
from
account-
that-
That is accounted as per the banking norms in the.
Fine. So don't take action till he files an appeal.
No, my lord. It is a case where he has come before this court with
All right.
unclean hands, wherein he had been dodging time since 1 year on pretext, one pretext or other, giving false dates to the bank, stalling the recovery. My lord, we kindly see exhibit P5, my lord.
You know, whether or not he has a right to file an appeal under section 17 or that is also not there because he has taken loan from you.
He's
We want to ask you whether he has a right to appeal against the order dated 23/5/2023 or he doesn't even have that right because he has taken money from you.
But I am not coming in
Then-
their way, my lord.
Then what-
My humble submission is that, my lord,
What
they have been
dodging and all that, Mr.
dodging the time since 1 year with giving false commitments for
That-
repayment. On repayment.
That will be dealt with by in an appeal by the debt recovery tribunal.
My lord, I place
We are relegating him to alternative remedy.
I,
The question is only of grant of protection for a period of 2 weeks till he files an appeal.
that is
Correct? Got it?
yes.
Why it takes so much of time for you to understand, right? Yes. In this mark the presence in this petition. Yeah,
Order of some report.
today. Yes.
May it please this honorable court, my lord. Please,
Yes, madam.
my lord.
Heard on the question of admission. Petition is admitted for hearing. Notice on behalf of
My lord, I take notice for respondents 5 and 6.
5 and 6 and
I am taking notice for the R2,
R2.
respondent number 2.
issue notice to unrepresented respondents. These people pray for and are granted 6 weeks time to enable them to file count. Yes.
Obliged, ma'am.
May it please. Public interest litigation what has been filed. See, direction to establish a playground, what's in the specific ward number 54 of.
So you are a councillor, right?
Yes, ma'am.
Corporator.
I am a corporator and.
So under which act this you are a corporator of which corporation?
Lords of this specific 54th division.
No, which corporation?
Khammam Municipal Corporation.
And it is established under which act? Telangana Municipal Corporation Act.
Yes, ma'am.
Who is the supervisory body under the act which controls the your body? Who can supersede also and this thing and issue any directions? Like Madhya Pradesh Act, I remember Karnataka also 323 power of supervision and control.
My lord.
Have you approached your anybody, any representation made or just
Yes.
one fine day?
I made.
Corporator felt like coming to Hyderabad, he came and landed in an office by PIN.
I've made representations.
Where?
Lord. Page 38, your lordships may see is my representation. Page 38, the paper book. My lord. The representation is made to the Commissioner Khammam Municipal Corporation.
A commissioner, see, only commissioner.
My lord, and page 39, I have made a representation to the collector, Khammam district. I made representation.
Who earmarks this area for playground? Collector?
Yes, my lord.
Heard of
Correct.
it.
As per the scheme that is issued by the government.
Petition is admitted for hearing. Notice.
I'm appearing on behalf of petitioners in this matter, Your Lordship. Senior counsel is appearing through hybrid mode. Your Lord.
Hybrid?
Yes.
Oh, senior come. Heard on the question of admission, admit notice.
Obliged.
You would have felt more happy if you would have argued instead of senior counsel. He didn't address us. Tell him senior counsel, it has been admitted. Yes.
But I have been muted, my lord.
May I please, Your Lordship?
12. 11. Yes. This is what, madam? 12.
1, 1, madam.
Which? Learned counsel for the
May I
petitioner.
please?
Sorry?
Sorry.
You want to argue that despite the fact we are admitting the petition, this is a public interest litigation, you will not get anything.
Sorry, madam.
You are appearing as an officer of the court to assist us, not an adversarial litigation.
Sorry, madam.
Huh?
My lord,
Yes.
I appear for the respondent number 11. There is a order in the WP 33318 of 2017. If that order is modified, my lord, we are ready to proceed with the elections. You may tag on to that.
The issue is, you have examined the issue, right?
Yes,
He is challenging this. He is seeking a declaration that the Telangana Municipalities Act. You have read it. Why should we tell you?
I read the.
Then no application to, so without applying the act, you are holding election. Then is grievance.
They are the municipalities notified under the Municipalities Act. The elections are not being held.
No. As we have understood, subject to, of course, like correction, that The grievance is that his stand is, petitioner's stand is, that provisions of Telangana Municipalities Act 1965 as amended in the year 2019 has no application to scheduled areas of state of Telangana. That's probably the issue. We are required to examine this.
But that act, contemplates these municipalities are notified. Unless that is challenged, this cannot be gone.
Scheduled area municipality has to be notified.
Madam, these municipalities are notified under the Municipalities Act. Then, Milord, we have also, the state government has also issued a GO how the ward members and how the delimitation to take place.
What happens to your relief?
May I please, your lordships? This bill is being.
No. Did you hear learned senior counsel that what he suggests is that you will have to amend your prayer clause for a fair and complete adjudication of the controversy involved. You are still focusing on arguing that will it appear in the newspaper tomorrow that counsel argued for half an hour with great difficulty, convinced the court, then notice issued. Why are you getting? This is a public interest litigation. You don't have a stake. What did he say? Did you understand? Or you did not like it?
Yes.
What should you do? What should have been your immediate response? Sir, please give me time to amend the prayer clause. You are saying that I want to argue.
Okay.
We will, if you want to argue, then order will follow.
Okay, Milord.
Huh?
Because I'm arguing on behalf of the scheduled tribes and scheduled areas of the state.
That doesn't make any difference on whose behalf. Whose behalf?
Municipality Act does not applicable to the scheduled areas.
Senior counsel, please, we will hear you on this. Let he insist that it should be heard today itself. So we will decide it today itself. You raised this objection a little while. Please argue now.
May I please, your lords? This bill is
We
being.
will not grant adjournment to you, right? This is a public interest litigation, wasting the time of the court.
Okay.
We will not grant you time. Please argue.
So I will file a better affidavit, my lord, with amendments.
This is what we are saying.
Because this is a public interest pertaining to the scheduled tribes.
No. So it has to be properly espoused. In case you are finding it any difficulty, we will appoint amicus.
Okay.
Shall we appoint an amicus
No, Milord.
to help you? He will help us because you are unable to do so.
I will amend that.
How much time? Simple thing.
3 days. 3 days.
Learned counsel for the beliefs have to be, you should here public interest litigation, you should have a different approach. He is not opposing you as this thing.
Yes.
That no, he should be killed. He is not this submission. He is only pointing out that this is until unless you seek that relief, no effective relief can be granted. You should have immediately said.
Okay.
That sir, grant me time to that. That's what we would appreciate.
My lord, please.
Yes.
It's a case of freedom fighter, my lord. I have raised, my lord, the department, my lord. The proceedings have been issued, my lord, for processing the claim. My lord, regarding the same, my lord, Lakshmi close the writ appeal.
All right.
And Lakshmi kindly grant.
See, Mr. Effect of your appearance. Mr. Praveen Kumar has come up with the law. This intra-court appeal has been filed against an order dated
You will not give rise for second.
Another.
Not at all. Yeah. Jesus.
So, Madam, right, delay condoned, you say before IA 1 of them.
I have a problem.
This not appearing.
So, Mr. Praveen Kumar, that emphasizes the need to your this thing also, councils, yours, that it's not necessary to contest every claim. See, right? Especially where dealing with encroachment, water bodies, public land, not necessary to file. You should come up with a status report, action taken report that this is what we have done.
In this, my lord, I am appearing for the
Okay.
respondents.
Delay we will condone, madam.
Very.
Heard on IA 1 of 23, reasons assigned duly support. You know that order. IA is allowed, delay condoned. Let the appeal be listed for orders on admission. Next week. Lordships. Next week.
After 1, my lord. I request a week's time.
List after 1 week.
Yes.
List for orders on admission after.
I have to respondent.
Oh, yes. It is listed at some place. There is one more petition.
There are four matters. But in fact,
Item, which other item listed today?
49 matter. 49.
49.
And there are 2 more items.
So we will hear them.
All the 4 together.
Mark the presence.
Yes.
List this appeal along with WA, along with WA.
Weeks, matter. The senior was leading all of us, matter.
Can we give it on 24th?
Matter.
On 24th,
23rd, sir. 23rd.
23rd August 23.
Right.
Yes.
Connected 5 appeals are there, same identical matter.
Give numbers.
See, please give the numbers to the court officer. They
Yes.
will-
Okay.
Huh? Whose person? Human Rights Commission did say the 14th August.
Same, madam. 14th.
Learned Council, the dispute in this petition pertains, no, in the instant writ petition, Human Rights Commission, Telangana State Human Rights Commission has entertained a claim. What? Huh?
What's the allegation is not these serpents and others are demolishing their houses.
14th August, you argue with reference to provisions of the Act.
Section
12, as interpreted by Supreme Court. Your powers have been, scope of powers dealt with, all these do not fall.
It's legally action.
Please, well, we have received the counters yesterday, my lords. Will file a formal reply, my lordship. Kindly
Learned counsel for the petitioner.
Counters.
Praise for and is granted.
on Monday, my lords.
A week's time to enable him to file rejoinder. What is this material?
My lords, we have challenged the sand miling policy, my lords.
Yes.
Challenge the officer.
Yes, petition is admitted for hearing. Learned counsel for the petitioner, praise for and is granted. Week's time to enable him to file rejoinder.
Kindly request, my lords, lordship, kindly pose the matter on Monday if possible.
No. Monday you want final hearing. You have landed in this court in 23. What's the sin of a litigant who is waiting before this court since 2005? Absolutely no justification for all of us. You are litigants. For you, he is your client who wants result today itself, if possible, certified copy delivered to the office by 4:30. It's not done. As an officer of the court, what will you suggest? What should we do? What should we do as an officer of the court? Supposing you would have been a judge, what you would have done if you had choice between to decide an appeal of 2005 and 2023? What you would have done? Tell us as a judge. Forget about this case. Tell us. Tell the answer. As a judge, we are.
I'm only requesting, as a
No, as a judge, we are asking you what you would have done. Then also you would have made a request. You are a judge, supposing. And there are two matters before you, 2005, 2023. As a judge, what you would have done? We are asking you, supposing if you are a judge, what would you do? Answer that.
priority on all matters.
So say so, no? I would have decided 2005 appeal. That's what we are doing.
God bless.
Next.
Please, Your Lordship.
Lordship.
I'm for the respondent number 1, Your Lordship. Last occasion we have to file.
For the petitioners, it shows that.
Sorry.
Yes, it's okay then. Yes.
Your Lordship, we are yet to file counter, Your Lordship. The party is suffering from conjunctivitis, Your Lordship. A week or 2 weeks time may be granted.
Counsel for respondent number 1, praise warrant is granted 3 weeks time to enable him to file counter.
Obliged.
So this is the matters.
So other similarly situated petitions have been, the identical petitions have been admitted. What is the number?
Lordship, so the 20th number was
Mr. Kapoor, the other day, one of the matter you argued.
WP number?
Number is 19855.
19?
55 of 2022.
We have admitted, no? We have admitted, no, that petition. What has been done? Madam C, what order 19855? Has it been admitted? All right. We will find out if you don't want to answer. The simple question is, say so, yes, that's what we are asking. Have we admitted it? Otherwise, we will find out from this thing if you don't answer. We'll admit.
Yes, they were
Cut off it. I understand. Understand, Mr. In that case, they were appointed beyond cut-off date. So therefore, interim relief. We are not saying that we are granting interim relief. We have only asked whether those petitions have been admitted. The answer should have been yes. No, so the submission is it should be dismissed, right? Your submission. The point is regularization. We will. Mr. Prabhakar will admit it. Heard on the question of admission, learned counsel. What's your name? Anand Kumar Kapoor. You appear for whom? Learned respondent number 3. Respondent number 3 submits that the writ petition should be dismissed. Paragraph, we see no ground to entertain the submission made on behalf of counsel for respondent number 3 and 4 as the issue involved in this writ petition is identified. What, Mr. Kapoor? You owe an extra duty to be fair to the court. You should have said that, my lord, before he said, we would have appreciated. That's the counsel for High Court. That similarly similarly writ petition involving identical issue has been entertained. This should also be admitted. This is what you are required to do.
My lords, item 26 also same.
All up to 26 admitted.
Item 25 also same.
No, this order, which is Mr. Kapoor, we have rejected your submission. This order, we have rejected your submission. We have admitted it, the petition saying, and this order is open to challenge before Supreme Court. Supreme Court. Yes.
Item 25 also similar.
We have not passed an order for linking the petition with that. Please file an application then so that other side has notice and we decide on it. And this is subject to, of course, challenge before Supreme Court, our order which we passed today. It should not have come from a council representing the High Court. This is what we expect. That even an admission of a writ petition you are opposing, it shouldn't come from a council. For the High Court, any other person can do it, but not counsel for the High Court has to be a gentleman above this thing. Not admitted.
It's admitted.
You said admitted.
It is not admitted. 19855 is not admitted.
Same order. This is not admitted. Delete everything. So what is your submission, Mr. Kapoor? Now finally, what is your submission? We propose to post these petitions. We have 1 minute. What you say doesn't matter. What we write matters. Correct? You appreciate this? Can't dispute. We are happy to hear. So in that earlier order, you are not, the petition has not been admitted. It has been posted for 17/8 to 23. We are posting these.
Earlier order that was passed by the division bench has been appealed by the High Court in the Supreme Court. They have filed a SLP against.
It is pending. This is all recorded here.
Not to contact needs of pertaining to the present state is the only ID number is important. Only request is because that is on a different booking part of case. And this can.
All right.
Therefore, I request you not to club it, have it separately. That is the only submission I wanted.
But why? They are not this thing. They are not seeking regularization in these cases. Then what is the different issue? Mr. We are not deciding it on merits today, Mr. Kapoor.
No, are they, Mr. Kapoor, are they joined the service pre 2014? These people. 2000.
Mr. Kapoor, broader issue is regularization of services. They are court staff. When they are heard, then you point out this is pre-14, this is prior 14, DB applies to this case, doesn't apply, SLP, this happened, everybody will be bound by the decision, Article 141, at least we are bound. Speaking for ourselves, we are bound under Article 141. So this issue, the hearing has been deferred because SLP is pending. We will not dismiss it on your submission if the larger issue is pending before Supreme Court? You find out, Mr. You find out.
Your Lordship.
All right,
All the
just a minute.
appointed in the year
No, we are not going into the facts, Mr. Please understand. This is what he is doing. You are also repeating the same. We notes this court at this stage is not recording a finding that who is entitled to benefit of division bench. We are simply adjourning it, awaiting decision of Supreme Court. You find out.
I'll find out.
The issue involved in this appeal pertains to claim of the petitioners who were appointed on contract basis on the post of typists and office subordinate in the district courts. Full stop. It is not in dispute. You don't dispute that issue is pending before Supreme Court.
Yes, it's. Fast track. Fast track.
Appointed as on the post of typist and office subordinate in the special magistrate courts in the district of Hyderabad and in Hyderabad and Rangareddy districts. Full stop. So you don't dispute that SLP is pending?
Lordship, it has.
You dispute?
It has.
No, you dispute SLP is pending? So not dispute, right? Say so. Because we were about to write admittedly SLP is pending. So before that, we ascertained whether what is your stand.
That it was not even numbered, Your Lordship.
Just
Only
admitted.
number.
This is not our job to number SLP, right? Huh? What do you expect us? Admittedly. No, Mr. You put in effort for a non-productive matter which is not being heard. That's our concern. That this whole exercise is taking in a place which is being adjourned without adjudicating anybody's rights. In that you want to oppose, say something. This similar issue is pending. There is an order. We are deferring hearing. For that, so much of resistance. No order is being passed. He is opposing the prayer. You have not argued anything. Yes. So and so Rangareddy, Hyderabad and so district, admittedly against an order, common order dated what's 12/6/2023 passed by division bench of this court in Mr. Kapoor.
4506 of 2009 and 09/6 of 2020.
Wherein a similar issue had arisen for consideration, a special leave petition has been filed, which is pending before Honorable Supreme Court. Full stop. This court, by an order dated 3/8/2023, passed in a writ petition which involves similar issue, namely WP 19855/2023, has deferred the hearing, awaiting orders of Honorable Supreme Court in view of aforesaid. So how much will you pay, Mr. Sanghvi?
Yes, Milord, I am coming. Milord, apart from part payment, what I try to say my client is, anyway, you have to pay the money completely.
Correct.
You are not, you are paying in your own account. So, Milord, I could persuade him, and Milord, the entire amount whatsoever due. Milord, my client agreed to pay by 31st December. Within 5 months he will pay.
No, how so that this thing, we entertain this application. How much will you immediately pay so that we issue notice on this petition?
May I just, before that period, may I just bring to this Honorable Court's notice?
No, that is a future event.
I'm not disputing.
And supposing
one mistake which I have made, that's what I wanted to say.
Perhaps Mr. Sanghvi, we were in that case not clear to you.
Absolutely not.
No, just a minute. We passed a 2-page order in your presence and perhaps not clear to you.
Absolutely not, Milord. My client is ready to pay. Yes.
See the order.
Yes, I have seen the order.
That doesn't mean that all balance amount at a future date in December. He said immediately how much will you pay?
Immediately,
Otherwise,
my client is ready to pay 50 lakhs.
That's what,
50
that's
lakhs.
what the,
Yes, my lord, your lordship, one mistake which I have made is, that's what I wanted to point out, that 11 crore 66 lakhs was the due previously. Thereafter 3 crores
how
and
much,
18 lakhs paid.
50 lakhs, how much, within how much time will you pay?
Not 4 weeks. Absolutely no.
Month end, minister. That's what brother says. Yes.
Absolutely.
Mr. So and so learned.
That 11 crores.
Let's see other, we are entertaining your petition.
That is not there. 11 crores 66 lakhs is not the due. As on today, Milord, I have calculated the due is 6 crores, 7 crores 25 lakhs something. He paid all.
We don't know. We are not, Mr. The scope of the writ petition is to examine the validity of the order dated 27/7/23 and to and we are concerned whether or not you should be relegated to remedy of appeal. By taking into account your willingness to pay the amount due to the bank, we are entertaining this writ petition. In this writ petition, we are not deciding whether it's 11 crores, 6 crores, 2 crores. Our bank owes you some amount. In the light of full stop. In view of order dated 3/8/2020-23, Mr. Sharad Sanghi.
Vijay Prashant.
28. 28 to
No, this all right. Today, yes, madam.
My case minute they were not filed.
Please supply.
No, they are
Filing.
You did not hear what the learned advocate general said. They will be filing it in the course of the day. Item 29 to 31 is in relation to GO 72. 32, 33, 53 are in relation to GO 73. One is to PG, one is to UG.
Yes.
On the question of petition is admitted for hearing. Learned Advocate General submits that the counter shall be filed. She has not read it even. pray for and granted 2 weeks time to enable them to go through enable them to go through the same and to file the rejoinder if so advised. But we have said subject to result, not state, right? All right. One week, madam.
1 week.
1 week.
1 week. After 1 week. Prepare a synopsis, Advocate General. You prepare 1 page date wise and then submissions.
Yes.
That's it. How much time should it take?
Lordships,
Both sides.
It's a very short question of law, Your Lordship.
10 minutes.
10 minutes. Yes, I'll not take more than 10 minutes.
If you have a good case, you can conclude your submission in 5 minutes.
Correct.
If no case, then only you take longer time. This is the
5 minutes would be a little difficult with Lordships, but 10 minutes is, I should be able to do it.
Fine. Mr. Advocate General, be on the alert mode. They are very confident, ready to conclude in 10 minutes.
Yes.
If 18th August. 18th August.
Lordships, sir. 18th August is that's given, Your Lordships. The only problem, Your Lordships, is in the counselling that has happened yesterday, last Saturday, Sunday.
17th August.
In the counselling that happened on last Saturday, Sunday, I understand the petitioners could not choose online. So that difficulty still continues.
There's no segregation.
There is no segregation
of seats prior to.
We have permitted there is an interim
Yes, Your
order.
Lordships. There is an interim order. However,
please file an application, right? Whatever
they did file an application, Your Lordship. They did file an application, but the problem, Your Lordships, is
what instead of orally saying something, you should put it in writing so that he gets notice. He is taken completely by surprise what orally you are saying. That's what, in case you want any further direction, please file an application so that they are put to notice.
Request to a small extent.
On 17th, Your Lordship's, my Lord, it doesn't take much time, my Lord.
Ah,
If very
the
small
counselling
issue,
is-
Your Lordship, subject to Lordship's pleasure, my Lord, Your Lordship will decide it.
They should say so.
If you are not permitted to exercise web options pursuant to our order, put it in writing that.
Yes, Your Lordship.
This is a
been made.
I totally understand.
This is a contempt, Mister. Contempt, not this thing despite an order. This is what you are saying, right?
Yes, Your Lordship.
Please put it in writing, put him to notice.
Obliged, Your Lordship.
And if anything wrong has been done, we are sure Learned Advocate General will take corrective measures.
My only endeavor in saying that, Your Lordships, was the second round of counselling that might be looked into. That was my endeavor.
Put it, at least they will correct themselves to.
Greatly obliged. I shall do it immediately.
You should.
I shall
they
do it
should
immediately.
know right here. They have no idea what you are saying.
I shall do it immediately.
Yes. Please put it in writing and seek a mention memo if it's so urgent. In case dates for this thing are notified, second round of counseling, you can approach us. Yes.
Obliged, obliged.
17th August.
17th August.
Otherwise, it can come up on a mention memo if you file.
Obliged, Lordships. Obliged.
What up to?
Well, I think 32 is slightly different. Till 31, Your Lordship, my Lord.
31.
32 is GOMS number 73.
73, that's
Same,
right.
same positions. It is
Yes.
only rules. You see, that's why I said one is UG, one is PG. This is the only difference.
Yes, but in my case, my Lord,
Therefore, the issue involved is completely different.
No,
So
but
we will hear you on some other date.
32, no, I'll just make one submission.
Issue is the same. We have to decide whether 100% can be allowed.
But in this case, my Lord, I'll advise my Lord, the petitioners to withdraw this. I will have no challenge to, my Lord, against 73.
Do you want to withdraw this today?
Just with a small clarification, because yesterday, Your Lordship, my Lord, heard in the aspect of local and non-local candidate. I'm covered under that. I have an order copy, Lord, yesterday's matter.
We remember that is for in relation to UG. You are now in PG.
PG. The
That's
same
the
applies,
difference.
but same applies.
True that.
32, Your Lordship may hear me for a moment, my Lord. Just 32.
Mr. Counsel, interim order is a precedent.
There is no interim order in this. Yesterday.
In
it
the
came up.
other case, yesterday we have passed an interim
Yes,
order.
yes.
You have been led by the news item saying that the candidate has won in the High Court. We wondered, it's an interim order, who has won and who has lost. Advocate General told us that we have not lost. Council for Universities said that we have not lost. So you are led away that interim order can be vacated anytime on an application being made. We don't know what will happen, but the news items say that candidate has won. So
This is governed by the presidential order. That's how I'm covered, my lord. Your lordship
we don't know, Mr. Are you asking our opinion? What should I do? If you have to withdraw it.
No.
Who prevents?
My lord,
If
sorry.
you have to amend the petition, amend it.
I'm sorry. I'm just saying I'm a local candidate. I will have no, my lord,
No, so you
grievance
want
in respect of 73.
You want it to be de-linked from 31 to 28.
Yes.
We will hear you in month of September.
My lord.
Separately.
Yes.
By the time this issue is decided.
Sir, I'm very sorry.
And that order will bind you also, obviously.
But half a minute, my lord. Just half a minute in 32, my lord.
We don't know, Mr. In respect of cases which are being adjourned, nothing productive is being done. Why do you waste your energy and our energy?
32, I'm not a non-local candidate. I'm a local candidate. That's
Are
why
we
I'm just
saying-
segregating from the others.
Are we saying that you are a local not a local candidate?
All others are non-local candidates. All other items, all other petitions.
No. Have we said today that you are not a local candidate? Have we said?
Petitions admittedly have been filed by non-local candidates.
No, you are wrong. You are wrong. In fact, their cases, they also fall within the same local because.
No, my lord, no. They are from the neighboring state. They are from the neighboring state.
No, Mr. Tirmal Rao, please, at least
32.
what we remember is that they have studied up to 10th class here, 2 years only they went out. So therefore, the class 7, the 7-year period would stand attract. Therefore, they would still be a local candidate is their case. That is why we have granted interim order yesterday.
That is yesterday matter, my lord. I'm covered under that. That's how I'm saying that.
Petition, right? So, Mr. Advocate General, file counter in his case. We are admitting the petition. It will come up separately in month of September. We decide this 17th August.
My lord. Well, the writ is
Third on the
challenging
question of-
73. The writ is
Third on the question of admission, petition is admitted for hearing. In case dates of second round of counseling are scheduled, you are at liberty to move a mentioned memo by filing an application. You don't understand what can be done. You are saying my case is different. We are delinking it. What can be done? It's not has been admitted for hearing. We will admit it. For this thing for cases which are being adjourned, you waste your energy and our energy also. We are also drained.
I'm terribly sorry, my lord. I couldn't distinguish properly, but I'm a local candidate, my lord. All these candidates are non-local candidates. I have challenged.
Therefore, it is listed for admission, therefore admitted. Learned counsel for the petitioner submits. That is an irrelevant argument according to us. Learned counsel for the petitioner submits that the petition
Connected is.
33 also, my lord, this is also along with the bank.
78.
53.
33 and
53 also stay.
list on 17.8.
53 also.
33,
And
53.
53 also.
53. Yeah.
34 is plus.
Ah. Oh. Your situation is better in the state, Mr.
Better, my lord, I find a detailed report also.
And you have now, you are on to the,
That's what I would request is, my lord, your lordship, kindly, I read the affidavit from my lord's perusal. My lordship, kindly take this affidavit on record, my lord.
no, what?
Lordship is being monitored.
Mr. Raha, special counsel, what we would have appreciated, that you should have prepared a chart-wise thing, that this is the direction, this is what we have done. So it would have been very easy.
But
Petitioner, have you done it?
I have answered it.
Mr. What you should do is what we want. There are two orders giving directions. So you prepare a chart that this is the direction, this is compliance.
I would also take steps.
So it will be very easy,
Yes,
right? It will,
I'll put it.
if it will not take less, more than, I believe, 5 minutes.
Yes, I should do it.
So shall we take it up later half of the day?
Tomorrow, madam.
Tomorrow?
Sir, tomorrow day after.
Not tomorrow. What?
Tomorrow, because I
Acha.
need to prepare all the things, my lord, with
No, no,
18
see,
districts across 18.
What, Mr. So, Mr. Prabhakar, you need to, don't prepare anything, everything. What you do is, what are the directions contained in the order dated first order? What is the compliance according to them, which paragraph? Then apart from this, you have to, in a separate sheet, you have to tell your suggestions, what else is required to be done at the ground level. We are telling that he understands that it is not an adversarial sort of litigation. They will do what it takes to do. But you are in a different capacity, not here to attack the government. You are here for the flood victims. Correct? So you tell us that this is what they have done, or even if they say so, but this is not at separate submission. This is what according to you has not been done, and what else needs to be done. You will find if you carry out this exercise, this case will not take more than 5 minutes. Otherwise, it has the potential of consuming time up to 4:30.
We shall.
Correct.
We shall do it.
What object is to provide relief. So which day? Day after.
Day
after. On Friday.
Learned counsel for the parties. Learned counsel for the
Counter is being filed today, my lord.
counter
Is being filed today, brother. Please receive the counter.
on behalf of whom, Mr.
R5, my lord. R5.
And what about 4 to 10? They don't want to fight. Mr. 1, 5 and
Respond number 3 file counter.
1 and 5 submit. One says that counter shall be filed today. No, 5. 5 says
4 to 6.
counter shall be filed today.
Yes.
One says so and so. Let counter, if any, on behalf of respondents.
7 and 12 already filed.
4 to 10.
11 and 12.
4 to 10, if any, be filed.
4 to 6 GP revenue is saying we will file counter today. 3 is already
He's
filed.
saying 5.
No, Srikant.
4 to 6, my lord.
4 to 6.
Then you said 5, right? 4 to 6.
Yes.
4 to 6. And 7, 8, 9, 10. Let 7, 8, 9, 10 counter, if any, on What status?
Report is filed.
Report is filed?
Yes. It has been served on the other side.
Only a couple of days ago, it was, so only one request, not the entire issue is about protecting the fund structure from.
Yes.
If that interim order or an order to that effect is there, not, it will suffice. The fund structure should not be breached because the downstream millets, there are residents and from.
Response number 6, my lord, irrigation department filed counter saying that, my lord, the allegation of breaching of fund is absolutely false, my lord. Fund is still intact in safe condition, my lord. We filed counter to this effect.
No, it is there. I filed even photographs also. I'll file a reply to that in that case. I'll put it in writing. But in order to millets, put a
We have caused, the irrigation department has caused damage to the bund.
irrigation department without any authority has disturbed the bund structure.
Absolutely false, my lord. I filed counter.
He wants to file a reply in view of stand taken by irrigation department of government of Telangana, namely respondent.
Maybe. But it's a matter where without calling for any tender, contracts have been awarded in favor of RP.
The council was saying that was covered. Not there. Oh, we thought. Yes. At the end of this is to be heard, right? That's what he's saying.
That's correct.
His payment is withheld.
That's correct.
Payment due to him has been withheld. There is an interim order.
There is already an interim order not to make the payment in there.
That's why he needs
So
to be
therefore,
heard. So shall we take it up after the motion hearing case like? So
next week, your lord.
no,
I have some personal inconvenience. Next week, your lord.
it is for him to this thing.
Having waited for so many days, this another 2 or 3 days.
Finally on Wednesday.
You give an agreed date. Both of you give an agreed date.
Well, Lord, finally on Wednesday, or next Wednesday.
Next Wednesday.
16/8. Please give a synopsis so that
I have already filed.
Date of date has been list of dates sort of thing has
Not
been given.
dates here, it is a form of facts.
Well, Lord, I just filed it in brief.
No, what, see, the idea is to synopsis is we have to write facts while dictating an order and to understand also, then he will
But
tell,
lot you wanted the
when he
list of
starts that I petitioner was born in the year 1957, 48 or say 38, participated in the freedom struggle movement, then we will be stumbling what is the issue. So you give this, who is petitioner, NGO, public spirited individual, when tender was issued, how it was issued, how it was granted to you, what was done.
Very well.
Like date wise, and next page is your submission 1, 2, 3, 4 case law, end of the matter.
Very well. Okay.
Shouldn't take more than 5 minutes for him to conclude. And we can put him, we can with those facts, we can control him. Otherwise he will.
In fact, I am not taking more than 5 minutes.
Already filed, Lord. I
Only
filed
3
it
points should be argued in this.
Just now. Very well.
That's the idea, is to cut short. If you want this case to be heard in motion, then you have to assist the court.
Very well. I'll do it.
Otherwise,
I'll
it will be admitted, then you, this thing. 23rd August. 16th August, Learned Senior Counsel for Respondent number. Has been awarded to you by nomination without inviting any tenders.
And another condition, not in the contract is specifically provided
And
that no escalation of prices. However, not 68 crores was paid in excess.
that's over
And
now.
that point has not been denied.
So this over your submission. we will say heard in part submissions of respondent number 3. This what, so we will record this also. Learned counsel for the petitioner. In this public interest litigation, the petitioner has
Meetings are completed, both sides was hearing today, your lordship. I have filed the synopsis as per the direction.
what this can't be heard like today.
It's a tank, your lordship.
And there is already an interim order, right? Protect
Your lordship, what's one thing. They have violated interim order, they have constructed road, I filed a contempt, your lordship. After filing the contempt also, the road was there, now it has been completed. The lordship kindly look into the GQ, your lordship, small issue.
Small issue, but
My lord,
ready.
my lords, I represent Learned Special GP appearing for the respondents in PIL, my lords. My lords, may I earnestly request my lords to take up the matter in the next week, my lords.
List of dates not, it's long.
Your lordship, has synopsis.
Yes. Yes, Mr.
My lords, I earnestly request your lordships to take up the matter in the next week, my lords.
Won't take more
Which
than
day?
5
Correct. Yes, madam, in this public interest litigation. When?
My lords,
tell us a date next week, any date.
Any date.
Next week, is it?
Next week, 17,
Earliest is 28th August, Mr. Because we want to be realistic, right? We are looking at the chart like this and giving a date. So, I mean, we don't want it to be fixed on a day when it will never reach. Right? 28th August. In this public interest litigation, the
Grateful to you.
Item 4.
Requires for counter. I appear for R1, 3 and 4. R1, 3 and 4, Lord. 2 weeks, Lord, for counter.
Yes. When it so and so phrase fund is granted. 1, 3 and 4. 2 weeks time to enable him to file counter.
Let's have 2 and 5 minutes. This one. For counter.
One second. Mr. Srinath.
Yes.
This is an endowment land.
Not so, Madam.
Not so. And it's not an endowment land.
May not such made such averment, we have disputed that and denied that.
No.
No material is filed in support
Because
of
if
that.
it's an endowment land, there is an order of the division bench.
Yes.
Where permission should be taken from the court.
It's not an endowment land. It's not so.
Item 42, letter of for general administration with scheme.
Permission should be taken and it should be before the DD. Only for irrigation department, it is a concession that was given by this group. Even then also, the permission can be taken, but it's a matter of because the single day. But for any other purpose, I should be listed only before the DD to see whether there is a genuine requirement and whether the benefit will go for the enrollment. That should be.
All facilities provided, madam. Report has come. We are asking, all facilities provided. What have you done? No, this construction is complete. Then you had undertaken June 23.
The report says, madam, June 23, it would be completed. These are prefabricated toilet blocks. Why is it? That is arranged. So permanent construction is going on while the temporary toilet blocks have been.
So when it will be completed, we want you to make a statement. Yes, madam. In this petition, the issue pertains to providing basic amenities to the students of Government Junior College 5th September 23. 5th September. You say make it 2 weeks, 3 weeks. 5th September. That's it. Let's do English. That is okay.
Your Lordships. Your Lordships kindly.
I can remember 42.
This matter, my lord, under the further orders of the Honorable Supreme Court, my lord, passed on 31st July. My lord, the RERA has been constituted and we have been directed to appear before the RERA. We have appeared before the RERA and the matter is now posted for final hearing on 19th August. May I request, my lord, your lordships may, my lord, close this writ appeal by giving liberty for us to raise these contentions before the author. I'm great.
Rahul, my order says all the contentions are open for you to raise.
Yes. That's all, my lord.
And you carried the matter to Supreme Court and withdrew, saying that you will appear before the
In this intra-court appeal, the appellant has asserted the validity of the CD from that appeal.
Please, your lordship.
Super.
Lordship, I am submitting the synopsis, my lords. Lordship.
And there is no evidence.
This thing here, freedom fighter, it has been detected. Mr. Praveen Kumar.
It's a case of no evidence. She filed up to 2017 is the rejection order. The filed litigation in 2022. Even the level judge also found that there is no prima facie evidence.
Okay. What notice has been issued?
Notice has been
Here,
issued.
here you some time.
Lordship, I am filing synopsis, my.
Give it to us. When September matter, we will hear you.
Lordship is age is now 95 above. Lordship,
perhaps it should.
On representation only, Lordship.
Perhaps, madam, perhaps at his age, nothing else matters but peace of mind. He should be contented. He did not participate in the freedom struggle to this thing, involve himself in the litigation, right?
I filed all the relevant documents.
No. Did he participate that to claim pension?
Yes, Lordship. From the beginning.
This statement is enough. that a petitioner participated, appellant participated in the freedom struggle with in an anticipation of grant of pension. So this is, you have fought for your country. Only to claim pension, madam. That means you are not a real patriot.
Pension is pride, my lord. From last 30 years is
30 years. So another 3 weeks, 30 years he has survived. We hope and pray that nothing will go wrong. All this is, madam. 12-9. Learned counsel for the appellant has furnished a synopsis to us. Synopsis is there. You have done your part. We will decide it on 12th.
obliged.
We will give you 5 minutes after this synopsis to argue.
Item 44G, Sridhar G. can attend this struggle to pay.
Alongside, I appeal for the respondents, my lord, in this matter. Requesting this matter to be taken up on Monday, my lord. We are led by senior counsel in this matter, my lord.
For the appellant.
You are not led by any senior counsel.
Senior counsel.
What will happen? You are also led by senior counsel.
Only thing was the last occasion, this honorable was pleased to order personal notice on 5th July, my lord. 2 of the respondents not been served, my lord. We have filed memo.
Mr. In a society governed by rule of law, nobody can deny that orders of courts have to be respected. But taking advantage of order of this police protection, you should not raise construction. Police is not there to ensure that without any hindrance you raise construction. Correct? Well, are you raising construction?
But construction is long back, it was raised in 2019, right? 2019.
You're not raising any construction?
No, we are not taking any construction now. There, people are residing now there. I have filed the photographs, page 99. Houses are being constructed long back. The contention of the first respondent is it's agricultural land of 5 acres.
No. So if there is an order of injunction,
yes,
you have suffered.
No, we are not suffered. We are not party to the suit. That is the contention. We are third party to the writ petition.
Then, Mr. If there is no order of injunction operating against you, how are you this thing aggrieved in this petition?
Because at 11th March 2023, police came along with.
See, Mr. The law is that even if a person who is not bound by an order of injunction, if it is brought to his notice,
yes,
he has to obey by it. If you, in case you are aggrieved by order of injunction, take recourse to such remedy as may be available. So long as that order of injunction issued by competent court stands. You cannot be permitted to flout it on the ground that the remedy lies under order 39 rule 2A.
Yes.
This is the ground in the appeal, right?
It is exactly case of the petitioner appeal before this honorable court that
this is what it is. Your appeal is only on this ground that instead of filing a writ petition, the respondent ought to have filed a petition under order 39 rule 2A.
They should have, that is what our contention.
That's what we are. But see, why should we encourage a person? Tell us, it's intra-court appeal discretionary jurisdiction, right? Even 226 discretionary.
Yes.
You tell us that the learned single judge had no authority to order police protection. And you are saying that permit me to flout the order. I will violate the order of injunction. They cannot even file the petition seeking police assistance, and they should file 39-2A where they will get an order after you know how much time and all that. We don't want to say that. But the question is, why by entertaining this appeal, why we should permit you to flout an order passed by the court?
We are not doing anything.
Then how are you agreed?
We have been agreed, Malad, because on 11th March 22, that's what, Malad. If your lordship will permit me, Malad. On 11th March,
of course.
was subject to your lordship because.
No, of course, Mr.
Page
No,
9.
we cannot but permit. We only want to explain to you our point of view so that now you can answer.
Only thing is, because
Which is the order passed by learned single judge?
page.
What does it say?
Page 8. It says to provide police protection to the plaintiff.
But your case is you are not violating this order of injunction.
We are not violating this order. That is our case. Our case is that,
not violating order of injunction.
Page 19.
So, 1 minute. 1 minute. So then please tell us, if you are not violating the order of injunction, how are you aggrieved by the order of the learned single judge providing police protection to them?
That is what. Page 99 for a moment is not.
99.
Page 19.
Yes.
These are the photographs where houses were constructed long back. Now I take your lordship, page 99 for a moment, your lordship, I can see. Then I take your lordship to the impugned order, page 8 of the learned single judge. Then your lordship will take to.
No, Mr. Who is this person? Whose house it belongs?
Yeah, that is one of the. One second, sorry. Page 10 for a moment, because
you are not a party to the writ appeal.
We are not a party.
No, you are not a party to the writ petition.
No, we are not a party.
Writ petition.
Yes, ma'am.
You are not impleaded.
Yes.
So you are this person standing in the photograph 99.
No, one of the appellant. One of the appellant.
So what is your grievance? You are not telling accepting photograph. We don't get anything. A person is standing in a shirt and jeans.
Yes.
And a belt, black belt.
Page 10, your lordship.
Therefore, counsel, you must, before adverting to document, you must tell us this purpose I am referring. So we appreciate. Otherwise, you have in mind what do you want to show. We see this person standing with the specs.
Yes, that's what. Just say. Page 10.
Who is he then? What is his name? What is he doing in front of this house?
These photographs to explain. Page 10 for a moment, your lordship. Page 10.
1 minute. Will you please explain how they are aggrieved by this order providing police assistance? He is unable to. We will hear him. But can you tell in one sentence what is their case? You don't know.
I am not aware.
Not aware. Very good.
My
Proceed
case
in your own way.
My case is that they are claiming an open agricultural land in the suit. In survey number 184, 185, 186 and 196. Whereas the appellants before this honorable court is in survey number 194. They have constructed the houses.
Just a minute. Respondents are claiming survey number
184, 185, 186 and 196. They are claiming 5 acres of agricultural land. Now, page 19, which I draw your lordship's attention, this is a particular house, one of the houses which is constructing long back. It is in survey number 194 by 1.
So, appellant is concerned with 194 by 1.
Yes. My main grievance is under the guise of that injunction order, they are trying to dispose us.
That's what we have been asking. You should say, my grievance is that in the garb of this order, I am sought to be dispossessed. We are asking, how are you aggrieved? How are you aggrieved? How are you concerned? You are showing us photograph. Photograph only shows a person standing in front of. It doesn't say that this house belongs.
Only to show that it's not an open land.
Yes, Mr. How can you do so? Police cannot dispossess him. In any case, police has no authority to dispossess. We will clarify this.
Yes,
this under this garb of this order, he cannot be dispossessed.
Yes.
You must, even if he's according to you, he's an encroacher, right? You must take an action for his removal in accordance with law. Supreme Court said way back in 1968. Note down 620. Police cannot dispossess him. Police, no, Mister. You are appearing for.
Police.
The police has this job of doing dispossessing people. Can it do so? Can it entertain a civil dispute and the garb of an order of the court? Can it dispossess people? No. That simple thing. You are not opposing the prayer made by him. You can't oppose.
But the judgment of this honorable court, my lord, where
We will clarify this order.
disobedience of the injunction order cannot.
We are not saying anything. He is saying that we have first ascertained that he is not disobeying we are recording his submission. He is not disobeying the order. The order of injunction pertains to survey number, this survey number. All right, Mr.
Lordship may kindly have it on Monday, my lord.
Hey, what Monday, Mr.? You don't understand all this whole thing. What have you got it? Nothing.
Just appearing as a proxy, my lord. That's the reason.
Don't appear. This court very dangerous to appear as
sorry, my
proxy.
lord.
In Bangalore also used to tell. Proxy means Advocates Act doesn't mention, it only recognizes two category of advocates. Advocates, senior advocates. Under which category? Proxy.
Sorry.
Have you filed wakalat? Then ask yourself this, what proxy? Whose proxy? You should be quicker and faster, Mr. You knew the subject, but
Yes.
Explain, right? All we are trying to know is how are you aggrieved?
Yes.
You should say, you have told it, but after a lot of effort and wastage of time. Yes, this intra-court appeal. Say that I will not appear in first court.
I apologize.
No, don't apologize. Why? We are not seeking your apology. What will we do with your apology? Tell us. What will we do? We are wasting our energy so that you are a young man and you will improve in the fond hope. Right? We all saying this in the fond hope that you will improve. If you don't mend your ways, best of luck to you. We felt like that you are a son amenable to advice. That's why we are saying all this, giving exercise to our vocal cords, which is already overworked. List on Monday.
Instead of Monday, Wednesday, because senior counsel may appear.
No senior counsel, you have done.
Thank you.
This order is in your favor. Senior counsel is not required, sir, for such a petty case. He is a proxy counsel, therefore doesn't know. You seek some inspiration from him. He has argued.
Yes,
don't appear. To seek adjournment in this court. Yes. Next, madam.
Similar, challenge the same order.
44.
No, 44 and 45 go together.
44 and 45. What is it?
Police protection.
Same order, madam, Monday,
Arising out of
44, 45.
But in this matter, my lord, replies have been filed by the appellants day before yesterday. But it appears pleadings are complete, your lordships.
Order till today. Kindly extend the interim order and he will also give the synopsis. Please extend the interim order.
Yes. She responded. Which period is 27 to 22? What people? 39. Pleadings learned mark the presence learned senior counsel for the appellant submits that respondent number 1 instead of filing a writ petition ought to have saying that you will be heard only on this ground.
No.
We are admitting it for hearing. For our memory, we are recording. You tell what are the submissions.
No, your lordship.
Learned senior. Please say. Learned senior counsel for the appellant has made following submission. Number 1, that the respondent number 1, instead of filing a writ petition.
But I appear even in this matter. This is also a case, my lord, wherein it's an intra-court appeal filed with leave. We were necessary and proper parties. Despite the fact that we are necessary and proper parties, we were not arraigned as respondents, and the learned single judge allows the writ petition at the admission stage itself. On the
Learned senior heard on this thing. In previous case, madam, allow his leave petition before admission. 46 heard on IA 1 of 21 for the reasons assigned in the 46 matter.
Yes.
Reasons assigned in the application duly supported. Appellants are permitted to file this appeal as condonation of delay. Reasons assigned duly supported. Delay condoned. Then dispense with IA 3 reasons assigned duly supported. learned senior counsel for the appellant prays for adjournment to enable and 2 we allow, 3 also,
Please suspension.
1
One is for granting leave. 2 is for dispensing with. Then
3 and 4 of course.
3 and 4.
And his 5 has to be 3 to 5 you are to be heard.
Yes.
But these 2 IS can be allowed, right?
These 2 IS can be, the other
Not
three
their
shall-
presence heard on IS so and so leave granted, then dispensed with requirement of filing.
Other 3
line accordingly, IA 1 and 2 of 23 are allowed. Yes.
The other
3 will
3
have
IS
to be considered.
Yes. But it is like this.
So will you argue after
Yes,
the
yes.
break
Yes.
today?
Yes. I'm ready, my lord. I'm on.
All. So on vacating stay, we will hear him. There is already a stay granted in your favor.
Yes. Now, I just indicate the issue, my lord, so that it becomes easier for the honorable.
Of course, yes.
Lord, the issue is like this way back on 2011-2015. Lord, I purchased this particular property from
2011.
20th of November 2015. I purchased this property under a registered instrument. The factum that I purchased the registered instrument in an affidavit sworn before this honorable court in a related writ petition has been admitted by the unofficial respondents. Then after I purchased the property.
Which respondents?
1 and 2.
One.
Then after I purchased the particular property, they were in that property, they were doing chit fund business and were selling some stainless steel utensils. They requested me to retain them till appropriate arrangement is made. But after I purchased them, since they were doing chit fund business, there was some sort of mismanagement with the chit fund business. The police have registered a case against them. That is after my purchase. Then I approached this honorable court because police has put the seal to that. When I approached this honorable court, please see page 41, a learned single judge of this honorable court, having regard to the counter filed by the official respondent, namely the 7th respondent, namely the police, para 7 of the counter affidavit, which order has been extracted by the learned single judge at page 41, says that it would be done immediately. Then what happens is these people move an application under 451 of the CRP. See, then that was dismissed by the learned trial judge. They come before this honorable court. This court allows their revision only to the limited extent of taking away their material over there. Then thereafter, they make a representation for handing over the keys to them. Now, the learned single judge, without us being a party, passes a direction. The keys which the police are lying with the police should be handed over to them. It is a fact that they admit my safety.
Earlier petition. In that these people is planning to be a partner. I just say happiness one day parties will let petition. Earlier petition, there were parties.
Yes, they filed implete there. They were not parties, but they filed implete.
So the fact that an order was passed in your favor was within their knowledge,
and
which was not brought to the notice in the subsequent petition, and you were not implemented.
Hello. In their implete application, they make an amendment admitting the sale deed.
I'll just submit first.
We will
Immediately after.
You got it?
Yeah.
Food for thought. Correct, we got it. Mr. Perhaps you cannot, I mean, if until unless you say that facts narrated by him are incorrect, probably it's a cause, no, subject to hearing. Prima facie, it's a cause which you can't defend. See, in earlier, you have admitted he claims title through a sale deed. You have admitted the execution of the sale deed. Previously, he filed a writ petition. In that writ petition, you filed an implete petition. In that writ petition, an order was passed in his favor. You had knowledge about that order passed in his favor. In the subsequent writ petition, you suppress this fact of an order passed in his favor. That was a fact relevant for adjudication in the second writ petition. Secondly, you don't implead him. How can you possibly defend this order? It will be very interesting to hear you in the second half.
The material facts, my lord, the material facts.
Any order, plus please tell, as a senior counsel, as an officer of the court, whether any order in your petition could have been passed in his absence.
I'll answer immediately after.
Still answer. Oh. All right. Thank you. Thank you. It will be our pleasure to hear you on this. Senior counsel, what? Yes. We'll hear. How many cases left now?
Your lords.
Huh?
The two governments are claiming the petitioner's land, one as enemy property and another as access land. What we have applied the copies for the enemy property to the Delhi, your lords. It takes time for the obtaining our RTA. The lords may have up to 3 weeks, your lords.
Yes, Mr. Hmm.
My friend says 3 weeks.
Oh. Yes, mark the presence.
GP is appearing.
Learned counsel for the appellant praise fund is granted 3 weeks time to enable him to file a petition to receive documents, right? Hmm. All right.
Yes.
Yes.
Yes. My lord, just I want to bring some more important facts which are essential, my lord, to decide the matter. My lord, initially the entire issue arises out of a registration.
No, so what's your case? They are not necessary parties to the petition.
Well, that's what I'll just come to that point. Before that, my lord, the respondent number 1 and 2 in the writ appeal, my lord, they are originally absolute owners and possessors of the property. And they were running a chit fund and kitchenware shop in the premises. They were running a chit fund and kitchenware store in the said premises.
Chit fund and?
Chit fund and kitchenware, my lord, the electronics, ware and goods orders. What happened, my lord, when a complaint was lodged under the Depositors Act, crime number 13 of 16, 2016 was registered, my lord, under the various sections of Indian Penal Code and Depositors Act. On dated 12/1/2016, this is very important. 12/1/2016. My lord,
date, please.
12 January 2016, 2016.
Yes.
My lord, as said, my lord, the sale deed was executed by the respondents, my lord, on 20/11/2015.
In favor of the appellants.
Yes. My lord, then, Lordship may kindly see, after registration of the crime under the Depositors Act, the property was seized by the police on 14/6/2016, my lord. 14/6/2016, property was seized, Pachama was conducted.
What date?
14 June 6, 2016.
Yes.
My lord, the respondents wanted to file a suit, my lord, suit for recovery of balance and cancellation of sale deed before the court below, OS number 263 of 2019. And now that matter is coming up for a trial. In fact, the written statements and the issues were framed, it is coming up for trial.
So OS in the relief in the OS is about cancellation of sale deed.
Cancel of sale deed. My lord, it was originally the sale consideration was 4 crores and they paid certain amount and 1 crore 86 lakhs was for recovery.
Yes.
My lord, the date of Panchanama of the police for this entire property seized is on the same day, 14/6/2016. My lord, was a part of my writ petition. But selectively, this Panchanama was not filed, my lord, except that they filed other matters.
Yes.
Now, the writ petition, my lord, I'll come to the point. The writ petition was filed by the appellates 4411/8 of 2016. 4411/8 of 2016, which is in page 25.
By the appellants.
By the appellants.
Yes.
Your lordship may kindly see in this writ petition, by the time, my lord, seizure happened, Panchanama was conducted, a crime was registered, they were all, everything is in their knowledge for the appellants. But here in this writ petition, page 25, they did not made us party. They did not made us party men. Then,
so you felt inspired by them and did not implement.
Yes,
lighter vein. Yes.
Then, my lord,
page 20.
It's a fact that, my lord, I filed an inferior petition. Petition filed, and now this writ petition is pending till today. This writ petition is pending.
He told us some order was passed.
No orders were passed.
Nothing.
See
What?
page 41. Page 41. Rest is pending, my lord. I have to verify whether any interim order.
No, he said some order has been passed.
Page 41. The learned judge records the statement made by the Home Department, namely the police, in the said order. Police has nothing to do in this matter. I'll come to that. I'll come to that, my lord. How?
No, what was the prayer in the petition? And there was, action in locking the premises was challenged.
Challenge.
Okay. So what was the order at page 41?
This was locked, my lord, by virtue of under the Depositors Act, section 5, they initiated the proceedings and law. I'll also read this, the recording of. Meanwhile, the learned AGP for home shall get instructions as to whether SHO Nalgonda 1 town has made any arrangement for shifting the seized property to some other place. This admittedly shows that, my lord, the respondents are in the possession of the property and they are running the business. And then, your lordships, since the property is more than 1 crore which was seized, because so far as chit fund is concerned, my lord, yes, since there are defaulters, there may be a victims of crime, chit fund can be seized. But this kitchenware property nearly about 1 crore is there. Then I filed an application under 451 of CRPC before the lower court seeking handover of the property. Then the court below dismissed my application. Then I filed a quash application before the High Court, which is criminal petition
When it was dismissed, your application under 451?
15/7/2019.
Dismissed. Yes.
Then I filed criminal petition before this honorable court 6435 of 2019. And Honorable Justice D. Nagarjuna ordered on 28/7/22, which I filed it as a matter stating that, my lord, let there be one appraiser to be appointed and to have a assessment of the property, and subsequent to the assessment, a proper sureties to the extent of value of the property to be furnished, then the property to be released. Then the total appraiser was appointed and he appraised to the extent of 60 lakhs rupees property. Then I furnished the sureties before the court below. Then I got order to be released. Then what happened, my lord, the superintendent of police.
So after this, another order was passed directing release?
Yes.
When?
Subsequently, my lord, this order by Justice C.V. Bhaskar Reddy is, it is on 8th February 2013.
No, this is 22. 28 July 2022, you said that CRP allowed and this appraiser was appointed and assessment was directed to be made.
Yeah. Yes, my lord. This order was not implemented. My lord, the respondent three, the superintendent of police was very actively hand in glove with the appellants that, my lord, he says, no, I won't hand over the keys unless you get the consent from this appellant. So that is how it was pending. Then I approached, my lord, by way of writ of mandamus. Then there was a direction, which is in the page 10 of the writ appeal, my lord. Lordships may kindly see.
No, but all the more necessary that when the police was taking a stand that, so you knew that these people are necessary or in any case proper parties to the petition.
Yes, it is true that, my lord, either of them, my lord, either the
all these contentions, Mr. I mean, you may be right on merits of the matter, but we were initially considering only the fact that you also knew that police also, you are saying that the act, so all the more necessary that you should have implemented them and so that the order, any order passed, they would have been bound. Now they are saying that we are not parties, not heard. This is that's why we tell young lawyers that never impose the prayer for impleadment, never oppose. So whosoever volunteers to come and wants to be bound by the order, then he should never be this thing.
Well, so far as this subject matter is concerned, it's in the nature of crime where I am an accused and the police are the complainant. Well, now they are claiming on the alleged saying which is the subject matter of the suit, which is already pending, and it is coming up for the trial. It is under the impression that.
See, Mr. You have been directed to, there is a direction to hand over the possession of the premises. No. Premises of a possession of which he is the owner as on today. Fact that, sale deed by virtue of a sale deed, till that sale deed is set aside, till that sale deed is set aside in OS, he is the owner of the premises. As on today.
The sale deed was obtained through fraud.
Whatever.
But that has to be adjudicated.
You have, so therefore, that will be adjudicated in OS.
Yes, my lord, that I am true that is still.
So as on today, as on today, he has some semblance of, so to put it, semblance of a right in respect of a property. So therefore, should he not have been heard before directing that possession of that premises be handed over? That's the only thing. The short ground is he has not been heard. This probably court, after hearing both of you, may say that you are very same order, but before issuing the direction, he has to be heard. That's the short point.
Yes, your lordship is.
So what we say.
At the same time,
the inevitable conclusion of this whole discussion is a remand. Otherwise, right of appeal will be affected of either parties. In any case, they were necessary parties.
True. My lord, I have to.
Therefore, we have to this thing.
No,
it has to be remitted.
Keys were handed over to me, and I opened the shop, and I paid the electricity bill. My lord, the time is at that junction, my lord, this.
In our opinion, as we are telling, we are not deciding the question of title in this writ appeal. That you are the owner, he is the owner. The order cannot be sustained on the short ground that they have not been heard. The inevitable conclusion is remand, which we may not like, but this is the inevitable conclusion. Why remand? Because the rights of either of you will be affected, of an intra-court appeal will be taken away if we decide the controversy. That's what in the pre-lunch session we told you. Perhaps you cannot defend the order in that it has been passed without hearing them.
So in this writ appeal also, my lord, there is a material suppression of the fact that the suit is pending.
That is the matter, you thrash it out. Who is guilty of suppression?
I have stated in my counter, my lord.
We are not, please, the senior counsel, please appreciate that we don't intend to deal with the merits of the claim of the parties in this intra-court appeal. All we are saying is that this order could not have been passed by the learned single judge without hearing them. You should have implemented them.
Yes.
That's it. We are not saying that you are entitled, he is entitled, who is. You should, if you are in possession, you should have said, yes, we will, this thing. We will argue before single judge.
Yes.
All right. Yes. Yes, madam. This intra-court appeal. Yes, so Mr. Senior Counsel, we will demand the matter.
I have nothing else to say.
Yes, that's why, presumably, but we thought of formally asking you.
Right time silence is eloquence.
Correct. This intra-court appeal emanates from
of grounds of appeal.
Page.
Para 3.
Para 3. No, no, no. Briefly stated that shop supported the order passed by the learned single judge. Paragraph. We have considered the rival submissions made on both sides and have perused the record. Yes.
Let this learned single judge for whom the matter would now go on, let the other writ petition also be tagged along with.
For that you can always, it will be open. This traveling beyond the scope of this. You say requested so and so, needless to state that we have not, we have already said, no opinion has been expressed by this court on the merits of the parties. It will also be open for the parties to file an application seeking analogous hearing of the writ petition, namely WP number 44118 for bar 2016, which has been filed by the appellants, along with the writ petition filed by respondents one. Open for the appellant. All.
I'm grateful to.
If we check in the statement.
My lord, I would request this case to be posted next week, my lords.
Why?
I would request this case to be posted next week.
Yes. You want next week?
Yes, my lords.
Learned counsel for the appellant prays for adjournment to enable him to prepare the case and argue this list next week.
Please complete.
But service, I have filed one only.
It's only for admission, right?
Yes,
Yeah.
yes, yes.
Not final hearing.
No.
Actually, notices were issued to the incomplete petitioner's lordship.
What happened,
We need to
sir?
file the proof of service lordship. Kindly have it after 2 weeks.
Learned counsel for petitioner prays for and is granted 2 weeks time to enable him to file proof of service on proposed respondents. Proof of service of what? Notice? Notice on proposed respondent. Yes. List up 2 weeks. 52. This is adjourned, no? 53.
Not a senior counsel, Mr. S. Ravi is appearing.
Huh?
I see Mary appearing.
Let the petition be listed before a bench in which one of us write his lordship's name is not a member. So that further hearing list bunch we were taking.
53. 53. Oh, morning, I got it.
Got it.
No, now you'll have to call the part head.
Part head matter.
Part head. What it up in
The list
58.
is over, right?
Yes, finally.
Shilan. So yesterday we were hearing a part head matter. No, please call that. We will finish it today. Yes, please.
But yesterday your lordships asked me to just put down the issues.
And your submissions. And your submissions.
Yesterday itself.
Ah.
I filed it at the hearing last time, your lordships have already seen it. It's not list of dates, relevant list of dates. May I read the
So 17A, we find at which page, Mr. 40 something, no?
But 17A.
Which page?
But just
no, just tell us the page.
Page number. 17A is at
page.
17,
it's at page 55.
55. And 2.6 of MOU 28 is at page?
It's at page
66.
66.
66.
Okay.
First two go together, my lord. First two issues, they go together. Wrongly 17A was considered wrongly and 2.6 of MOU 2 should have been considered. The third one is on the conduct. The third one is on the conduct. Whether to put they have any lawful authority at all to unilaterally, without notice, without raising any dispute with APGPCL, simply appropriate the energy to themselves as if it is their own. And as if they have supplied their own energy to us. That is the issue. Third one. The fourth one is if the Transco is claiming its share on the basis of the MOU, its own share on the basis of the MOU, then is it not, can they contend that the surplus power in terms of the same MOU will not apply? See, it's a contradictory position. Then my question which came up incidentally, 5 and 6 go together, but actually. Whether the issue is the judgment of the Supreme Court, it's also only whether a supply license was required by APGPCL under the Reform Act 1998 and whether anything in that judgment entitles AP Transport Discount to exclusively claim power of stage 2 where no such issue was at all involved in that case. That's the second one. that arises out of their petitions. Third one is whether, sixth one. Sixth one has got two parts. Whether AP Transco has any right in law as the licensee to the surplus power on the ground that APGPCL has no license in the teeth of the judgment of the Honorable Supreme Court, and more particularly after coming into force of the Electricity Act. Whether the AP Transco's contention that APGPCL had no option except to supply the entire surplus power to AP Transco as APGPCL had no license is not wholly devoid of merit. Lordship may just turn to page 173 of the complaint. 175 starts at 173. This is the grounds of appeal. Their grounds of appeal. Please see on 75, the last, number 6. This is the issue. The learned single judge ignored the crucial fact that APGPCL had no license to trade generally in electricity, as pointed out by the Supreme Court, and in such a situation, it had no option except to supply the entire surplus power to Transco, and the provisions of the Memorandum of Understanding, contrary to statute, are null and void. But where the whole thing is, where does this come from? This is their ground. This is their contention that APGPCL has no license. Therefore, they are going to give it to us. Under what law? Under what? Even if it is under the judgment of the Supreme Court, nothing. Supreme Court said they don't need a license. That's what the Supreme Court said. After 2003 Act came into force, the Act itself says no license is required by generating. So this contention, where does it stand? The action, impugned action taken here is in April 2004. After the 2003 Act is coming to now, my Lordship, permit me, I quickly go through with my thing on each of these issues with the notes I have given. I'm saying it is their contention that the once the MOU is entitled to it under some law, when there is no such provision in any law.
We had given submissions. Written submissions he had given.
Written submissions. It is not the just written submissions.
We have got your written submission.
Yes. But the first issue I'll address, I'll also refer to where I've dealt with it in my principle. Whether the impugned order of the learned single judge is not expressly erroneous or unsustainable, that the learned single judge erroneously conferred only 70 days. But quickly, I'll just deal with it and allow me just take convenience compilation, the impugned judgment. Just 3-4 paragraphs I'll just read out.
Next one.
Well, on page 15. Eight lines down, the sentence which starts with under stage 1. Under stage 1, my plots have got it. On page 15, 8 lines down, under stage 1, the utilized energy of participating industry shall be, should have read unutilized. My lord, is this
One page 15 is not there.
Yes. No. Brothers copy is different number. All right.
Convenience compilation.
This convenience compilation.
It's in the convenience compilation. The lordships may not worry. Everybody has filed it differently. Some have filed 3 types, some have filed the lordships. You have a confusion to no end.
Yes.
Yes.
Well,
Under stage.
page 15, 8
line.
8 lines down.
Yes.
And at stage 1, the unutilized, the word utilized should have read unutilized, a typing mistake. The unutilized energy it should read. Of participating industry shall be exclusively allocated to APSCT. Under stage 1. No dispute about this. That is the provision of stage 1. Then they learned that subsequently under stage 2, it was agreed by all the petitioners with the industries in public and private sector that the ACP, that the unutilized power generated shall be allocated among the other participating industries required power other than APSCT. This correctly, the learned single judge has noted that there are two separate provisions with regard to this, one in MOU 1 and MOU 2. Now what the learned single judge has done, my lords, turn to page 21. Please, 19, madam. The learned framed. The lordships goes through all the submissions. I won't put your lordships the trouble. But the framing of the issue itself started the defense. Please see. Question which falls for consideration is as to whether the petitioners have any right to claim for use of the quota from the surplus, that is beyond the quota to which they are entitled to in proportion to the on par with the rates as applicable to the energy consumed within the allocator. The question of rates never arose. It was not an issue. Nevertheless, then your lordships may go to page 21. And this is the error. On page 21, sorry, please see on page 20. My lord, the sentence which starts got on reading of the said judgment. My lords have got that? On reading of the said judgment. That is, he is referring to the Supreme Court judgment on which they rely upon. On reading the said judgment and surrounding circumstances leading to such dispute, there was no dispute nor any issue regard to the entitlement of the participating industry from out of the surplus power beyond the quotas fixed. No doubt, clauses specifically say that it is the participating industries who are entitled to such energy as generated by the third respondent. This is the observation made. The next line is, even in regard to such surplus energy found beyond the respective quotas, there is no specific clause under any of the terms and conditions herein as to the rights which are applicable in respect of any surplus which is found and which is being again redistributed among the participating industries on pro rata basis. Contradictory. The lordships have seen, notice stage 1 this, stage 2 this. Then in the before this this sentence, it says that the clause says that it should be among participating industries. Then the learned judge goes on to say there is nothing in there with regard to the surplus. Then my lord, on page 21. Relevant clause in the MOU which are applicable to the sole question arising in these matters is clause 17A(b). This is the error. Because it is noted 17(1) refers to only stage 1. The issues arise.
This, according to you, does not apply.
Apply. No. Learned judge went by this. Then the learned judge held very peculiarly, my lord. The rest of it, everything becomes. He held that AP transfers entitled to the power under 17A, but that power which comes to them, they have to only supply it to us. The rate at which they supply it to us has to be decided by agreement between AP Transco and APGPCL. There is no basis for that arrangement. Basically, my lord, they are the respondents. The AP Transco is in appeal against that finding. They find how the rates at which I sell can be by agreement with APGPCL. The rates at which I sell are regulated by a regulatory commission. That is the result. So that's the question. Now, my lord, just go again. Please go to FOU 2. I just wanted to point out 2 or 3 more clauses. That's coming to my second point, the second issue, my lord. Whether the learned single judge ought to have considered and applied only clause 2.6 of the MOU. Let's see. I've already read out some portions, my lord. There's 2-3 more clauses. Page 60, your lordship, see. The second recital, my lord, and whereas, there is a third paragraph. And whereas the participants, excluding AP Transco, TS Transco, are medium and large scale industries and have industrial connections with AP Transco, TS Transco for their consumption, and are hereinafter referred to as the participant industry and collectively referred to as the participating industries. So, there are 3 terms in this agreement. One is participants. Participants means all the participating industries and TS Transco. Then there is a term participating industry. Participating industry means only the participating industries other than AP Transco. Lordship, see the definition of participating industry here. They're trying to define. Because on next page, on page 63, clause 1.17, it says participants, participant industry, participating industry means and includes the concerns as defined in the preamble. So that preamble I'm coming back to one to show who are considered participants. Participants is everybody. The participating industries plus AP Transco, wherever that term is used. Participating industries means the industries, that is the participants other than AP Transco. That is participating industries. As per this. Now read 2.6 along with this version. I have read it to your lordships. The lordships, please I read it again, otherwise I read a lot because also refer to 2.8. I want to show 2.6, 2.7 and 2.8 are connected together as one chain. When a participant industry for any reason is unable to utilize its full share of energy from APTPL, it shall give an advance notice of at least 15 days before the billing of the month to APTPCL. APCL will then reallocate the surrendered energy of the participant industry on pro rata basis among those of the rest of the participants who require additional power. However, when the advance notice is not received by APTPCL within the stipulated period mentioned, the unutilized power shall be fully allocated to AP Transco. Now, madam, please go to 2.7. There are 2 conditions. What happens where that industry which does not want the power gives and does not give? Where the participant industry gives notice mentioned in 6 above, then there are 2 situations. During restriction and control period, that means when there are power cut restrictions, then there is one set of conditions. Then during when there are no power cut conditions, another set of conditions. During restriction and control period, APTPL should collect full costs from the reallocated participant, including AP Transco, during the RNC period. During non-RNC period, the power surrendered to APTPL shall be first offered to the rest of the participating industries who require additional power. Power surrendered to APTPL shall first be offered to the rest of the participating industries who require additional power. Such industries will pay full cost, that is fixed and variable, for the additionally allotted energy. Any power left after this allocation will be transferred to AP Transco. APGPCL shall, however, collect only variable cost from AP Transco on such power allocated to it during the non-RNC period. The participant industry not utilizing its share of energy during non-RNC period is liable to pay fixed charges on that part of the share of energy so transferred. So there are consequences. For the person who surrendered his power, there are consequences. If other industries, participating industries take up their power, then the other participating industries will pay both fixed and variable cost. If the other participating industries don't take up that power, then it goes to AP Transco. What happens is the person who surrendered will pay the fixed cost And APGPC, AP Transport, to whom the default supply is, will pay only variable cost. Some little difference in power cut period and non-power cut period. If it happens during a power cut period, then AP Transport has to pay the full cost. That's it. Then 2.8, where the participant industry does not give advance notice for unutilized power to APGPCL, such unutilized power shall be transferred to Transco as follows. So it only deals about the other condition. One is advance notice given, one is advance notice not given. But this is the position. Then please see page 69. Tariff. Clause 3.2, the whole of it deals with page 69, 3.2. Deals with APGPCL when it makes supply of the power that is generated. How will the tariff, how will APGPCL's tariff be determined? So there are principles laid down. On this basis, the tariff is determined on a monthly basis. And my lord, I just one more line here.
So what was impugned in the petition by you? What was impugned in the petition by you?
Impugned
in the petition, challenged.
I'll just can I just finish this off and I just come to it in a moment. I'll take your lordships to the list of dates and I just in a moment. Please come to page 63. I want to point out two things. The last one was 2.1. The participants agree that both demand and energy to be generated out of the proposed generating station shall be shared by them in proportion to the number of shares held in the expansion project from time to time. That is what. Let please see the last line of the next paragraph. The demand and energy delivered shall be regulated on a monthly basis by the party of the first part, that is by APGPCL. In other words, the regulation of this energy, how it is to be allocated, will be determined by APGPCL on a month-by-month basis. Obviously, they have to follow whatever is here. Now, I will come to this one. Please see the list of dates. Before I go to the third issue which I have said is really what is the cause of action. Let my note, the list of dates.
What?
Sorry, I was looking for Mr. See, Vinod, I didn't see him here. I didn't notice that he's sitting there. Concern, my lord, I'm arguing. If I don't see him here, I have to myself not feel comfortable. That's why. But that's got the sufficient. My lords may see. First one is 17/10/1988. I've taken your lordships through it. All the page numbers are here. 19/4/97, the second MOU. Then please see some sequence of events. 1997 is MOU 2 was entered into. Then 1999, the Electricity Reform Act was brought into force. On 2000, the Andhra Pradesh Electricity Regulatory Commission passed an order rejecting APGPL's contention that no license was required and granted a conditional exemption under section 16. So they granted a conditional set license was required, then they granted a conditional exemption with a whole set of conditions. Then on 18/6/2001, Honorable High Court dismissed the appeals against the APRC's order. Then on 23/2004, the Honorable Supreme Court pronounced judgment in appeal against the High Court judgment holding that no license was necessary under the Reform Act for utilization of the energy generated by APGPCL and utilized by the participating industries, and that it would, however, be necessary to have a license for supply of energy to sister concerns which are distinct and separate entities. That's all that for 2004. They sent bills apart. What do I mean they sent bills? Well, supposing APGPCL delivers, generates, allocates 1,000 units. It gives 1,000 units at its first pass. 10 units is taken away by AP Transco as wheeling charges to convey the energy here. Now, 900 units are delivered to the consumer. But the same consumer also gets, his total consumption will be more than 900. Then total consumption may be, say, 5,000. So what they will do is take 5,000 units as minus 900 units from APGPCL, and the AP Transco will bill for. This is what the billing pattern is. So that is what they've done. Then after that, without notice, subsequently revised the bills, removing the surplus power and treating the surplus power as if it is their own. They revised the bills. That is 900 now, which they had given. Meanwhile, 900 bill was given by APGPCL, we have paid to them. Now, so after issuing a bill by accepting that allocation, they unilaterally revised. No letter was sent to us. No explanation was sent to us. No notice was sent to us. They just simply revised it. They orally asked. Orally they said, it is because of the Supreme Court judgment that the energy is ours. You don't have a license. Orally this was said. But repetitions were filed. That is the matter arises from that. On May 2004, writ petitions were filed. 6/12/2004, the common order of the third single judgment, which is impugned in this writ appeals. And both parties have filed. Now, my lord, please come to third issue as I have listed. Third issue, I'll read it out, my lord. Whether AP Transco had any power or authority under the law to unilaterally arbitrate without any notice and without raising any dispute with APGPCL, appropriate to itself a surplus power from stage 2, which it had received as a bailee, and bill the participating industry for such power allocated by APGPCL as if the power was owned and supplied by AP Transco. My lord, first question. Can they do this as an instrumentality of the state? Can they do it without if they wanted to help us with some proposition? Could they do it without notice or giving us an opportunity to? That's one. Lot of time and water has flown, my lord. I can't beat this ground too much. I'll have to go past this ground before your lordships. That's why after 2004, I can't beat the same drum anymore. In 2004, maybe, my lord, for the interim order, it was good enough. But at this stage, my lord, after the writ appeal, I don't think I'll beat the drum anymore. But nevertheless, that was the thought. I'm just pointing. Then, assuming they were wanting to dispute the allocation, the allocation energy generated is generated by APGPCL. Property in that energy, electricity is held to be goods.
Oh, good.
That felt it.
Yes, yes.
Yes. So, the property in those goods.
Sales tax.
Tata case.
No, my first case in electricity is arose from state of Madhya Pradesh, where electricity is held to be goods.
Correct, Tata's case.
The sales tax arose as the sales tax.
Then, my lord, they said somewhere in one judgment, they made in NTPC's case, they said electricity is good. They reiterated Constitution bench, reiterated it that electricity is good. But they said electricity can be dealt with, it can be stored, can be done this. Therefore, it is good. The stored part of it was removed in a subsequent judgment. They said this one aspect.
It can't be stored.
That's, they clarified that in a subsequent judgment later, but that's not material. All I'm saying, my lord, is property in the goods was with APGPCL. The contract is that the moment APGPCL puts that electricity after allocating for conveyance onto the lines, title transfers to me. At that time, the AP Transport title to, if 1,000 units have been allocated to me, then once that is delivered there, 100 units they take away as billing charges. The title to 900 units is transferred to me at that point instantaneously. 100 goes to AP Transfer charges. 900 is title transfer takes place on delivery.
Sake of clarity, I am asking on factual aspect. Have you paid the expenses incurred for the electricity extra units you have consumed?
APGPCL has billed us and we have paid them. What happens with APGPCL is, if we don't pay their bills, everybody uses coercive power of the consumer. APGPCL says, I'm not the lien on your shares, the auction your shares.
You have paid the bills in respect of this consumption of extra electricity. Surplus.
Yes.
And what is this revised this thing demand by Transco?
They just took away the allocation of the surplus power from stage 2, minus stage.
So
we did that as if it has been supplied by them.
We want to understand on fact, since you have already paid the bill in respect of consumption of surplus energy to APGPCL, what is this revised demand about?
Just in accounting, madam.
No, what is it under what they are demanding this 26/4/2004?
Their own bill. By treating this 900 surplus energy as not.
They have, he says that they have paid to APGPCL in purpose. What is this bill amount? 2004.
APGPCL has loaded 1,900. That 1,000 is taken billing charges. So they are entitled for 900. So let us say particular unit consumption is 5,000. 900 they will bill it as per the rate under the APGPCL has also a power tariff under the account. So 900 will be billed at the APGPCL power tariff.
And it is surplus.
No, I will tell you surplus. This will be billed at 900 units.
This in these things
only in respect of such water and it's 5,000 against 5,000 total commitment. Let's say there was surplus available with APGPCL instead of 900. We took 1100 APGPCL. This 200 will be surplus. Yeah, that's correct. That's surplus. APGPCL. The 200 surplus, APGPCL, they have these people if they get bill at APGPCL package. Now the government transfer says this 200 they will have to be billed as per the tariff rate.
Surplus case, these petitions want to
be billed at APGPCL tariff.
This surplus you are saying it should be billed at APGPCL tariff, while the state says it should be billed at the discount, the regulatory commission.
The discount will adjust that energy, deduct that energy. Now what they did is that the surplus energy part said I will not deduct.
No, that surplus energy they want to bill as per their tariff.
No, they say that they are the owners of the surplus energy.
That is why they want to bill you on the tariff.
Yes.
That is why we are wanting.
That's
while you are willing to pay and paid as per APGPCL tariff.
Yes.
The state, the transfer is saying you are not entitled to pay at APGPCL tariff because it is our power. No, it is our power, and we will bill you only as per our tariff.
You have concluded at our tariff.
That's all.
irrespective of APGPCL, what you have paid to APGPCL,
We are not
what
concerned.
APGPCL.
That,
So therefore, my lord, the legal proposition which I, therefore, my lord, the
So therefore now we are clear on facts. Now you can go ahead. This was missing all along since yesterday.
in fact,
I know. So that's
my
what is-
electricity went over there, went out in my house this morning. This figure work which I told your lordships, I made one.
Probably they knew that you are arguing this matter with the division bench. Mister?
I didn't bring it with me.
That's why he's sitting here, extreme left, not visible. What mischief have you done? You didn't supply electricity to his premises as he was arguing this matter? Yes. So.
But now, the legal point. Energy generated by APGPCL under the agreement is to regulate make the allocations. According to the MOU, I understood, and actually what they did was, has been being done from 1997 onwards. Same thing, nothing, no change. They've done it. Now, that energy, once it is put on the bars, on the electricity thing there, the title transfers to me. For this 900 units.
That we have understood. You have already told us.
I'm developing a legal proposition.
Yes. So you say that electricity, the property in goods, that is electricity, belongs to APGPCL.
Yes.
The moment it is consumed, it is given to you.
Once
it is made available.
For carriage. Conveyance.
So then,
according to you, is a carrier.
and
so the temporary, momentary possession of the electricity from the time it is put into AP transport system to the time it is consumed by me, what is it? They are in possession of that electricity as what? As a bail. The legal position is this. So can a person who has received goods as a bailee set up title to that goods? Impermissible in law. In other words, it is called conversion. A bailee cannot set up title to the goods.
Yes.
They cannot. Ownership, my lord, must pass only in two ways. Delivery under a contract of sale and on receipt of consideration. Here, delivery has never been done to AP Transco under contract of sale to them. Second, AP Transco even today, what they are claiming as energy generated by APGPCL, they have not paid anything to APGPCL either. If they are claiming that part of the energy is theirs, as a bona fide thing at least, what they felt should be paid to APGPCL, that also has never been done.
Is that issue open for you to be raised? It is between APGPCL and
they will take care.
I am on a legal proposition, man. No. I am saying that the title in goods is vested in me.
Correct. That legal
they cannot
position is
they cannot claim transfer.
bailiff cannot set up a title.
Yes. Well, so that is now if that is the situation, if the bailiff cannot set up a title, then how is that revision of bill and treating that energy as their own and as if it is their energy that has been supplied to me, how is it sustained? This is the issue. That's the legal. Now, let me go to the last issue and come back. I've shown from their notes that what they say is, APGPCL does not have a license. Therefore, under law, they claim, under law, they are entitled under law to the surplus energy completely. They say no, they don't talk about contracts and all the rest of it. Their stand is under law. We see the ground again once more, not page 183 of the company. So that is what I have to argue, my friend. Maybe I'll have to come come again after they do it. After they argue it again. But please see that 183 once.
183.
Page 175. 175.
Is there memo of appeal?
Is that memo? So their argument, the crux of their argument, which they said the learned single judge didn't consider, is ignore crucial fact that APGPCL had no license to trade generally in electricity, as pointed out by the Supreme Court. And in such a situation, it had no other option except to supply the entire surplus power to Transco, and the provisions of the memoranda of understanding, which runs counter to the statute, are null. In April 2004, the Supreme Court judgment dealt with under the Reform Act. Reform Act came to an end on 2003. The Electricity Act came into force. The action, influent action, is taken in 2004. So at the time when the influent action is being taken, the Electricity Act 2003 was in force. And Section 7 of the 2003 Act specifically says that no license is required. Section 9 says captive generating plant, you can do it shareholders.
This clause 6, can we not look at the stand of the Transco in relation to the claim being made for supply to sister concerns, which the Honorable Supreme Court said any of even the sister concerns will have to be treated as separately, because and you need to have a license. That is the purport of the judgment.
May I just explain that? Shall I show the judgment?
We'll complete. You go in your own way.
Yes.
We raise that.
Yes, I'll answer it straight away. My Lord, please take the judgment. It is from page. I'll only read a few parts.
Yes.
It's in the compilation, my Lord. It's at page 83. 83.
Page
83.
Convenience compilation or what?
Convenience compilation. Convenience compilation. I have argued everything only for the convenience compilation. I have not referred to any other.
All right. Yes.
Please see page 95. Para 22. On consideration of the rival submissions made by the learned counsel to the respective parties, in our view, the main question which obviously falls for consideration in these appeals is as to whether APGPCL is required to take a license under the law for utilization, sale or supply of power generated by it to the participating industries, their sister concerns, and the companies to whom shares of APGPCL have been transferred by the participating industries.
So it has been held that APGPCL does not require a license.
They said, well, I just read those three paragraphs, your Lordship will get clear. What they held, my Lord, is, I just put it briefly. They held that APGPCL to its own shareholders, whatever is being supplied, does not require a license under the 1998 Act. That's the Reform Act. So all a question coming around under the Reform Act does not require a license. Then they said,
does not require license to supply to its shareholders.
To its shareholders. Because it is manufacturer and self-use. So there is no question of a license. The license used to be called a supply license. In the 1998 Act, the term was known as supply license.
And for supplying to sister concern, it requires a license. It requires license.
They may be related in some way, but they're separate entities. These separate entities are not shareholders. And therefore, if you want to supply to sister concerns, you require a license. And the third is, if any participating industry transferred their shares to some other industry after purchasing it, then the other industry will stand in the same place as the from whom they purchased from. In other words, the rights to elect share of power runs with the shares.
Which para? Participating industry.
I just take it. Please see page 99, my lord, placentum A, B. Page 99, placentum B. Placentum B. We therefore hold, my lord, we therefore hold that electricity generated by ABTPCL and consumed by participating in this other plan under the memorandum association does not require to have any license for such utilization of the power generated by company. All that we want to clarify is that this is not in view of equity in favor of the participating industry as held by the regulatory company. In fact, it is permitted on equitable grounds. Under the law, there is no requirement. They clarified that. That is this. Then your lordships may go to page 5, page 100. From para 34 onwards, next question regarding sister concerns. On page 99, para 34, we come to the next question regarding sister concerns. Then your lordships may go to page 100 and the end of the paragraph there. Just one page. Next page, page 100, end of the paragraph. We are therefore of the view that such a clause in the memorandum of understanding would not do away with the requirement of having a license for supply of electricity generated by APGPCL to such concerns which may be under the same group as participating industries, not the participating industries themselves. So this is the last point was covered, page 101, 41, para 41. We now come to the question related to industries to whom shares have been transferred by the participating industries. But this has been held. It's first. Para 48, page 106. As a result of the discussions held above and findings as recorded by us, the position that emerges is that participating industries and industries to whom participating industries have transferred the shares for consumption within the limits of the value of the share capital would only amount to captive in consumption and no license would be required under any provisions of law. So they covered the transferees. Because the regulatory commission in one of its conditions had said transferees will not be entitled to any share of power. But that's not the issue before us in this case, my lord, and so we did not.
So therefore, what is it has been held like this. So next is what?
Now, 2 points here. One is no license was required under the 1998 Act. The second is under the 2003 Act. Sorry,
2003 section 7 this generation was free, no license required. That already told it. Captive generation also no license required.
So 2003 has the question of license doesn't arise.
Then
now their argument therefore that because APGPCL does not have a license, only all the surplus, only we are entitled to the surplus power. Where they get that? There is no statutory provision to that effect. The lordships may take it from them, ask them the question, put it to them. But I am saying, what I am saying is, this is their ground, this is the issue that they have raised. They say nothing about the memorandum of understanding. Even the memorandum of understanding is wide to that extent. And for the reason that you have no license, APGPCL has no license, the supply cannot be made. But when Section 9 came in the Electricity Act, it was subsequently amended. Now let me just see that. So they say that please see, my lord, captive generation, please see the second proviso that has been inserted subsequently. Section 9. They tried to make it clear because still people were saying you require some kind of a license in some states. To clarify it, no license shall be required.
Right, you have made your point home. Which synopsis? This.
Yes. My lord, in this case, my lord, it's not the case of APGPCL, but that they have complied with clause 2.6 and disclosed the information, my lord, that the power, this is the excess power available because it was no notice was 15 days. Notice
So
was
this
given.
we have written that under clause point 2.6 you become the owner as participant industries didn't give advance notice to APGPCL. Next.
Then, my lord, after my lord, the judgment, my lord, was delivered by the Honorable Supreme Court, my lord, is 2004-10 SCC 511, my lord, wherein, my lord, it has been held, my lord, that only to the extent of, my lord, power is allotted to shareholders, to that extent, my lord, license is not required. Any excess, my lord, even the allotment, my lord, if it is made excess power, they are not entitled to make it in view of the judgment of the Honorable Supreme Court.
Now, what is submission? 2004 judgment, what does it say?
My lord, it says, my lord, page 3, starting July. Honorable Supreme Court in so and so case, my lord, has held that no license is required for utilization of energy granted by APGPCL are utilized by the participating industries.
Now, where are you reading?
Page 3 of the synopsis.
No license.
No license is required for utilization of energy generated by APGPCL utilized by the participating industry and concerned holding shares of APGPCL. The court further held that license would be required necessary for supply of energy sister concern. But here, my lord, our case is, well, only to the extent of shares, my lord, the power allotted to you as per your share capital, my lord, you are entitled to. As per the judgment, after delivery of the judgment, my lord, whatever excess power, my lord, cannot be allotted to the shareholders because they do not have license. To the extent of the shareholder, to the extent of excess power. And only then.
So then you must tell us which legal provision provides that they need to have a license.
Well,
1998 Act, no license under 2003 Act 7 and 9.
Yes.
Do not require any license.
Bound by this, my lord, MOU 1 and 2, my lord, MOU 2, my lord, after.
Where MOU 2 provides that they should have a license.
No,
It can't provide.
That's what challenge.
Express prohibition, express stipulation, statutory provision contained in a law, section 7 and 9 can't be this thing. Your agreement cannot provide contrary to what section 7 and 9 provides. In any case, even if assuming there is an agreement.
Well, that's the main our plea, my lord, after, my lord, because the view of the judgment, my lord.
Transmission is license. Yes.
Well, it stated the even page 3 itself, my lord. Point 9, my lord. The participant industry are only entered. पूरा लाके GPC है. This is not the it's getting to grade carriage.
Ah, yes.
Yes.
Yeah, but you have been heard, right?
The council.
You have been heard to full extent yesterday, today.
Yeah, now
we don't know.
So Prashant is on video.
Is a council
They're not audible.
the council for APCL, my lord, they would have argued for.
He is unable to.
Ah, yes. Yes.
My lord,
1 minute, he is arguing now. Don't interrupt him.
I'm sorry.
You should have appeared. It's going on since yesterday. Yes.
My lord, that is, my lord, our case, my lord, our claim to the excess power, that is our case.
All right. These are your submissions.
Yeah,
Right?
my lord, your lordship may see, my lord,
All right.
page 5 on the same submissions.
All right. Thank you.
This is the admitted letter, my lord, which they have actually accepted, my lord. Even in their written submissions, they have accepted APGPCL. I'll just read this letter, my lord, which we have addressed to the APGPCL.
See the submission document.
Page 5 of my submissions. Submissions page.
Yes, yes. Read.
In the letter and reference, so that APGPCL furnished the allocation of particulars for the month of April 2004. As per the Honorable Supreme Court judgment, my lord, in so and so the same, not entitled to allocate power to participant industry beyond the extent of their shareholding without obtaining license. In violations of the above mentioned Supreme Court judgment, the APGPCL, my lord, has allotted surrendered energy to the participant industry for billing month of April 2004. That is after the judgment, man. In view of the above, APGPCL was requested to revise the allocation of power to the participant industry according with the Supreme Court judgments by letter dated so. Hence, it is requested not to consider stage 2 allocation furnished by APGPCL while letter reference to it. Event of non-receipt for revised allocation will be online.
No, this is the communication between you and APGPCL, correct?
My lord, they said that we have revised the bills for April and May, my lord. Why we have revised, my lord, after the judgment? My lord, we have written letters to my lord APGPCL not to allot the power. Hence, my lord, we have issued revised bills, my lord, by claiming that power as AP transfer power. And the judgments, my lord, which we have placed before lordship.
No, so therefore we have understood since you are the owner of the electricity.
Yes, ma'am.
And you have a license to transmit the same, therefore they are liable to pay tariff.
Tariff as per tariff
order.
These are the judgments too.
This
judgments
was
which are
submission.
placed before lordship. They say
Correct. And what happens that you are a bailiff and you cannot claim
I'm
title?
not a bailiff, I'm claiming the.
So you are saying that
I'm owner.
by virtue of clause 2.6,
Yes.
you become the owner. The moment you are owner,
yes,
you are entitled to charge tariff. As per your tariff order.
Never a bailiff to the extent of that.
Oh, that's what.
Yes.
Okay.
And the billing process, my lord, I'll just bring it to your lordship.
He has not gone into the process.
My lord, the billing.
No, once supposing if we uphold your power to issue the bill, then it goes. He is not that billing process. We can't examine. In
How?
220.
I'll just draw out page 72, man.
No, he is only questioning your authority, not the manner in which you have done it. A manner also that without hearing, but
what? Just I'll bring billing, my lord, 3.4. Okay. Subject to the provisions of Article 2 and 3 of the
page
72, my lord. Billing, my lord. It is agreed that bill shall be raised. Second. Separately for the power consumed by participant industry out of 172 megawatt power station.
So as per clause 3.4, you have raised the
Yes,
bill.
but the last, in case of, my lord, I just read this, that the bill shall be raised by and in the name of APGP. However, AP Transport shall assist the APGP in preparation of their bills. Further agreed, the participant industries, including AP Transport, shall pay the dues of energy charge on or before the due date stipulated in the bill. In case of participant industries having contracted demand, both AP Transport and APGP, the billing shall be done first on the proportionate rate of APGPCL and then for the balance the rate of AP Transport and TS Transport as per the tariff order. That is what has to read into it.
All right.
And my lord, one more, I am also participating industry. Yeah, I am also entitled to the power as per 2.6. My lord, if an excess power is both ways. I also applied, my lord, saying that I am also participating industry. Whatever excess power, my lord, given them 15 notice. That also they have not allotted. Neither, my lord, the excess power, they have not declared what is the excess power. It has all been, my lord, shrouded in mystery, my lord. They have never informed us. They never said, my lord, that actually there's some carcass between all the parties except transport. Totally, we have lost, my lord. Our investment is about 48.5% in that. My lord,
That's it.
Yes.
Yes, that's it. Now, Mr. You are APGPCL.
My lord, I appeal for the other participating industries. My lord, I just want to bring one fact to my lord's notice.
Other participating means you are with him.
Yes, Mr. Gopal Chaudhary, my lord. I'm sailing.
Fine.
Just one judgment I want to bring to my lord's notice, my lord. After the judgment of the Honorable Supreme Court in the year 2004, my lord, where they said for the electricity supplied to sister concerns require license. Basing on that finding, my lord, the Transco has raised demand, my lord, against all the sister concerns who, my lord, availed the APGPCL economical tariff, my lord, till then, APGPCL's power till then. So when these demands were raised, my lord, against all the sister concerns to pay the differential price, all the sister concerns, my lord, approached this Honorable High Court, my lord, and filed a spate of writ petitions. I'm just passing on the writ petitions, my colleague will be passing on the judgment passed by the Honorable High Court, where, my lord, all such demands have been quashed. And this judgment has become final. May I just request my lords to kindly sue the judgment, my lord?
No. So you want to say that the similar demands which have been impugned in this petition have been quashed?
Yes, which were raised against sister concern, my lord, were quashed and that has become final.
No, Prashant, is it demands raised by the Transco?
Yes,
on the sister concerns?
Absolutely.
Same demands, right?
Yes, my lord, for the differential tariff.
No. Here, what is impugned is differential tariff.
Absolute differential tariff is what is being assailed.
We asked you, Mr. Chaudhary.
But what my friend is saying is, in that particular thing.
No, we are only trying to understand from him whether a similar demand which was impugned in the petition.
Yes, the same ground.
In this petition.
License, so it is mine.
Just a minute, Mr. Similar demand issued in respect of other industries has been quashed.
Yes.
That's what we are asking. He is saying differential this thing, so that is creating confusion. You should say similar demand which has been impugned in this petition has been quashed. Simple, right?
Yes.
Why are you saying differential this thing? He has not argued anything about differential thing.
Only difference between the two elements is they deducted what we
Mr. Chaudhary, on facts you should be fair to the court. Either it's a similar demand.
It is similar, my lord. Only thing is quantification was done slightly different. That's all.
Very different. They say as against whatever the GPC of they have paid to GPCL that has been deducted. So that is why differential duty. Yeah.
Similar demand.
Similar demand.
Page 22, my request not.
So, Mr. We are recording your submission that similar demand has been quashed in the writ petition.
Yes, sir.
Right? When is the order dated? 8/10/2010.
Last may kindly come to page 22, my lord.
Array, Mr. This should have been your first submission, Mr. Chaudhary. This should have been your first submission that similar demand quashed, order attained finality. So, just a minute, Mr. So, no writ appeal was preferred against this order?
Yeah, no writ appeal has been preferred, my lord.
No writ appeal filed?
Yes, sir.
No writ appeal filed by you?
To my knowledge, now, my lord, they are.
All right.
My lord, this year. Actually,
Wait. You tell us, you give us slip whether appeal has been filed, what happened. We will find out. That's it, Mr.
Yes, my lord. Paragraph page 22, last paragraph was relying upon me.
Page 22.
Yes, my lord. Last paragraph, my lord. It begins with to sum up, my lord.
Yes.
To sum up, the AP Transco was not the owner of the goods, energy supplied by AP GPCL. To say that it is.
5 minutes to reply. We have heard you at length, 1.5 hours.
One clarification, my lord, on this. One of the things that was held in this order is that they were as a daily, even if they say that they did no. That does not give a cause of action.
No. In addition to these reasons, what is your response to the?
Yes, but only other reason which is given by my friend is that there is a presumption that 2.5 advance notice provisions are not done. Now, what happens, my lord, is in this batch of appeals, my lord.
Not the writ petition. This is over.
No, that's all. That's it. Not in this batch of appeals. The AP TPCL has filed a counter and a paper. So what is all lying there?
No. So what you make your
is all these requirements of participating industries notice, informing it to all the participating industries who are entitled to it. Was a regular process being done since 1997? It was there.
What regular process? What he submitted, no notice was given. Therefore, we have become owner under clause 2.6.
This is not.
Probably you are responding to his submission. That's what we presume in rejoinder.
No, there's no basis for that. Notice was given in every case. Participating
was it your case before single judge that notice was given?
Yes.
Which paragraph of the writ petition you have played it?
But I have not said anything of that sort. Because they cannot claim.
So then, therefore, you cannot argue something on factual aspect which was not pleaded before single judge, which was not the ground of challenge.
That's why I'm saying that has been stated by APGPCL in their counter filed in these proceedings.
Which paragraph?
That my lord, counsel is there, my lord, online.
We don't know. He's not saying anything. It's not invitation like this thing.
It's
not a wedding taking place, so we will invite everybody.
He's online. He's online.
My lords, I beg to appear for APGPCL.
No, it's too late, Mr. Too late in the day. He is making a rejoinder submission.
I was waiting for the submissions to be made, my lords. I was always online. I was present yesterday also. Lordships may permit me, I'll just bring a few facts to Lordship's notice.
5 minutes. We have heard senior counsel for 2 hours in all we can't devote more time than this thing.
No, my
Yes,
lords, I'll
we
not
know
take more than
everything.
5 minutes. I'll not take
Submission.
more than 5 minutes.
Submission.
Very well, my lords. Obliged. My lords, I'll just rebut. I'm sailing with the petitioners on this issue, my lords.
It is,
I'll
so
just
then he has argued 1.5 hours. He has argued senior counsel. 2 hours we have heard it. What else?
My lords, just to rebut the 3 contentions of Transco. My lords, the first contention of Transco seems to be.
Your rejoinder is over, Mr. Chaudhary. Over, no? Thank you. Yes. Yes, Mr.
May go on.
Minutes are 1 minute is over.
My lords, the three contentions raised by Transco, my lords, before my lords. The first one is that as a participant industry, it is entitled to surplus energy to the extent of its shareholding. My lords, I request my lords to kindly take up volume 2 of the additional material paper book that the Gas Power Corporation has filed. This issue was decided way back in 2002 itself.
What issue? What issue? What issue?
Whether Transco as a participant industry is entitled to surplus energy to the extent of its shareholding in APGPCL. This issue.
That clause 2.6 says it is entitled.
Yes, my lord. I'll just submit, my lords. Without reference to 2.6, they are entitled to was the submission made.
No, under clause 2.6 it was entitled.
Yes, that's the second argument, my lords, that under 2.6, when no advance notice is given, they are entitled to, notwithstanding 2.6, being a participant industry, they are entitled to surplus energy to the extent of its shareholding. That was another submission made before my lords today. And the third was, we've never intimated anything to the Transco, and it was kept in
Mr. Chaudhary has said that was not the ground of challenge before the learned single judge to do revised demand that we had given notice. That is fact is not pleaded. Have you pleaded which para of the petition? What is your number? Tell us.
My lords, we are respondent 3, my lords. We filed the counter. We filed the counter affidavit in the writ appeal, my lords, bringing all these facts and additional material paper book on record.
So you are supporting the petitioners, right?
Correct, my lords. We are supporting the petitioners. My lords, may I invite your attention to page 65 of volume 2 of the additional material paper book. I'll just point out
additional material paper book. Here.
We filed volume 1 and 2. I invite my lords to see volume 2. I'll just point out a few letters, my lords. That's it.
Yes.
My
Yes,
lords,
yes.
page 65, to address the first contention. This was the letter addressed by Transco to APGPCL way back in 2002.
Yes.
I'll just read, my lords, just one para. As per Article 2, Clause 6 of MOU 2, the surrendered energy of participating industries is to be reallocated on pro rata basis among those of the rest of the participants who require additional power. Since AP Transco is one of the participants in the 172 megawatt stage 2 power plant, we are entitled for allocation of surrendered energy. Hence, it is requested to allocate surrender energy to the extent we are entitled on pro rata basis on our share of 48.2 megawatts. My lords, the response is on the next page, 62, which they have accepted and not challenged it. They've always understood what the terms of the MOU were. On page 66, this is the reply by Gas Power Corporation.
So you are appearing for Gas Power Corporation,
Yes,
right?
Yes, my lords. The petitioners as well as Transco are the shareholders of Gas Power Corporation.
So you are saying your client did not contest and accept, right?
Their client, my lords.
Yeah.
This is the letter addressed by Transco to GPC.
Transco.
GPC.
The reply is on page 66.
GPCL is his client.
Yes.
So he's saying that we did not dispute and own.
No, we did not accept.
Acha.
Your lordship, may I read, my lords? With reference to the above subject, it is brought to your notice that APGPCL shall allocate the surrendered energy of the participating industries on pro rata basis among the participating industries who require additional power. Please note the definitions of Article 1 of MOU 2 under clause 17. Participants, participating industries mean and include the concerns as defined in the preamble to this MOU. In the preamble to MOU 2, the word participating industries is defined as follows. Participants excluding AP Transco. Hence, AP Transco, which is excluded from the definition of participating industry, is not entitled to get surplus power as per the provisions of MOU. This is in answer to the first contention raised by Transco that they are entitled to surplus power on pro rata basis with reference to their shareholding. They are not entitled because they do not fall under the definition of a participant industry. The second contention which was raised before my lord is that advance notice was not given, therefore their power under clause 2.6, which is not correct, my lords. We filed to illustrate this. We filed the entire procedure and correspondences exchanged between Gas Power Corporation and the shareholder, where 15 days notice was always given every month. I'll just the same volume, my lords, page 62 is the letter addressed by APGPCL to all its shareholders, elaborating the procedure under clause 2.6. The billing cycle is from 23rd of every month to the 23rd of next month. So 15 days advance notice should be given by the 7th of every calendar month. This is the procedure which has been set out in this letter, my lords. I'll not trouble my lords by reading everything, but it is given, but you have to give before 15 days. It should be on or before the 7th of every calendar month, so on and so forth. Pursuant to this, your lordship may now kindly go to page 17.
Notice in the case with the setting of the procedure is different.
No, but,
Yes, my lord. I'll point out the notices.
1 second. You said the Transco is not a participating industry, and this letter is addressed to participating industries. Where is that? You have sent it to the Transco also. Please, your earlier contention was that the Transco is not a participating industry. If that is the case, this letter is not addressed to participating industry, the Transco, because it is only addressed to participating industries.
My lords, this is only for the purpose of billing, my lords.
No, that is true, because if they are not entitled for the additional surplus power, they will not be entitled to.
Basis, they are not, my lords. Only if the procedure prescribed under 2.6.
You know, Mr. Please understand. Please understand the query. This letter is not addressed to Transco because they are not participating industry as per your submission made. So therefore, don't refer to this. That's what brother is saying. Because you yourself argued that Transco is not a participating industry.
Yes, my lords, for the purpose of clause.
And for this thing, we don't decide this question whether or not it is a participant industry between the communication on the basis of a communication between the parties. We will have to interpret saying that it doesn't depend because we can't say that you have sent a communication like this, therefore it is not a participating industry.
My lord, it's there in the very MOU.
Reference to MOU, you should have said that it is not a participant. For that, you need not rely on the communication.
Very well, my lord. I only pointing
either here nor there.
And that too, this communication is of the period 2002, while the dispute relates to April 2004.
Correct, my lords. They've always understood this. They've never claimed anything. Before, my lords, now a contention has been raised that we have not given
whatever you are arguing, which paragraph of the order passed by learned single judge and where you have taken, please tell us in counter. Like pointing out something is different, right? Anything, this is not an original proceeding. We are examining in this intra-court appeal the order passed by learned single judge. There has to be a factual foundation for all this. Anything like this won't help you. Please tell us which paragraph of your counter you have pleaded like this.
In the counter filed in the writ appeal, we have brought all these to the notice.
Writ appeal, no counter. Writ appeal, no provision in law to file counter. This we have been telling everybody. If you come across any provision, please tell us. We will learn something. That in appeal also counter can be filed.
It is not the case before the single judge, my lords. There is no observation made that 15 days notice was not followed. Therefore, Transco has become the owner. This was not the subject matter of controversy.
You,
Had it been, we would
Mister,
have
you are relying on him to buttress his submission. You know what he is doing. He is saying that he is relying, he is, will sail in the same boat and see what is he arguing. Yes. All right. No, please don't this thing. We are hearing. You are close to missions. We are
a little bit more to say, but just I won't take much of your time. The lordships have mentioned about single judge's judgment. This stand was never taken before the single judge. It's not dealt with by the single judge. And it's
So we are asking, we will say that a specific query was put to learned counsel. He is unable to point out where he has done. This all we are noting it down with all seriousness. Saying something for the sake of won't help him.
My lords,
Yes.
may I clarify, my
So
lords?
you only want to this thing tell your client that I had argued.
My lords, as rightly pointed out, this was
Next,
not
what
a
else?
subject matter of controversy before the single. Therefore, we did not bring these documents.
Then why are you arguing this in appeal?
My lords,
Yeah,
before
we will
the
say.
previous bench, before the previous bench, a query was posed whether this 15 days
No.
procedure was followed.
We don't know previous bench. I was at least not the member. I don't know.
My lords, I'm submitting, my lords, let Transco deny whether it is correct or not. When a query was posed from the bench, we were compelled to file a counter affidavit enclosing all these documents, though this was not the subject matter of controversy before.
So we have noted down, not subject matter. We are not going to decide on this. Anything
Yes,
else?
my lords. So let Transco also not now raise a contention that this procedure was not followed.
Mister, we understand whatever else has been argued. If you say something else, those submissions are appreciated, but not reading communication. This is not an argument. Reading communication between the parties.
My lords, I'm just rebutting the contention.
And we are not bound by those communications and the stand you take, right?
My lord, the other contention that 15 days notice was not followed, we filed material. It's part of volume 2.
Where is that?
Further, my
Where is that 15 days notice
May I
given?
point out, my lord?
Please point out.
Kindly
Please.
take page 70, my lords. I'll point
Which?
out how it is.
No.
Of volume 2.
No, Mr. Counsel, please tell us which para of your counter pleaded that petitioner industries gave 15 days notice.
Counter in the writ appeal we've stated, my lords, not in the writ petition.
Will not look into it. No pleading in the writ petition in the counter.
Very well.
Counter filed to writ petition. Is there a pleading?
No, my lords, there is none.
Then he himself is saying that that is not the ground. Anything else, Mr.?
My lord, just that we have filed documents to show 15 days notice was followed. They were aware. In fact,
Which document? What is the law that document without pleading can be looked into?
very well.
What do you say? No, we want your answer. You are an officer of the court.
Yes, my lords, we've.
It can be looked into without pleading any document, any stage.
My lords, we were permitted to file a counter affidavit in the writ appeal. Along with the counter and pleadings, we have filed these documents, my lords. So I only can support the strength of these
No,
documents
which?
on basis
No,
of
no.
the counter file.
Which order you are permitted to file counter in appeal? What is the order dated writ appeal? Which writ appeal? There are so many.
My lords, I'll have to verify the docket. And this was.
No, so this is the burden of the court dealing with the delivering judgment. We should find out when you were permitted, right? Yes.
My
Next.
lords, so it was accepted.
Next.
My lords, the earlier bench went into all these.
No. Where, Mr. Earlier bench? We are not part of this. File an affidavit, earlier bench. You file your own affidavit. This is not the subject matter of you are supporting industries or making their life more difficult.
We are supporting the industries.
But
It is Transco
then why to make their life more difficult? We don't know whether you are supporting or not. From your submissions, it doesn't seem to be so. Yes.
I repeated that, my lords.
Thank you.
Nothing more to add.
All right. Thank you.
My lords, I beg to represent the AP Transco's, my lords, Andhra Pradesh Transmission Company.
So all this is over, Mr.
My lords,
Ah.
there are only
You are
two additional
appearing, you are supporting whom?
We are for AP Transmission Company, my lord, supporting Telangana Transmission Company. My lords, in addition to
Order
what
passed by, you have filed an appeal against the impugned order passed by learned single judge?
my lords,
Huh?
my lords, we filed.
You have filed?
We've preferred writ appeals, my lords.
So what ground you are challenging this order? All the cases stop. Mister, he has argued, no, given 5-page note. Why why you should not come to court, mister? You are a young person. You are this senior, Mr. Vinod Reddy has argued on behalf of Transco. You don't know what he has argued and telling that I am appearing for Transco. You adopt his submissions. You adopt his submission. All right.
Adopt his submissions, my lords. In addition to that, there is Article 7 of the MOU, my lords, second MOU, which speaks about an alternate remedy. Our submission is that we've not acted as a statutory authority. There was an alternate remedy of arbitration, which was not raised before the lower court.
You woke up very late, right? After adjudication by single judge, and after 18 years, you are telling that we should relegate them to arbitration.
Because there are matters of evidence is what my respectful submission is. There are two stages in which it was.
Now we have understood that they should be relegated to remedy of arbitration. Fine.
My lords, because there are two MOUs, my lords. In the first MOU, there were 7 parties. The second MOU, there were 24 parties.
Second MOU, you are referring to clause 7 of second MOU, correct?
My lords.
Yes.
My lords,
what else?
Once the power goes into the grid, whether it's coming out of the first MOU or the second MOU is something which
doesn't.
matter of evidence is my respectful submission, my lords.
All. Yes. What else?
My
You
lords,
adopt the submissions made by senior counsel? Yes. Next. That's it.
I'm obliged. In addition to that, this is the only contention. My lords, I may be permitted to submit a brief note, my lord, 2-page note. If your lordship
We don't know. It's for you to submit.
I'm obliged.
Young people, we would advise that they should come to court. This is meant for, like, he should be there addressing us on video conferencing. He's in the court till 4:45. You are lighter when we are telling like that, and you are a young person sitting in the comforts of your home and addressing us, right?
Apologies, my lords. I'm based out of Andhra Pradesh. That's the reason.
No, that's all right. All right. Mister, all these things are said in lighter vein. Don't take it seriously, right? Yes.
Prashant and the other council, and
They are from Andhra. Please.
I'm obliged.
Judgment, it was not asked before the learned single judge.
That's what we told, no? The council felt offended when from his face when we asked this, that this is not your case. Can you do it at the time, like saying something?
They never told us that this, when they raised this demand,
we will not.
Just 2 minutes. Just give me.
We will not go into that question.
That this question only of
he has argued.
Vision for giving notice. The notice things was coming up for the first time here.
No, he has.
Argument.
Mister, he has admitted that it has not been pleaded. He refers to some interim order. Which order we don't know. This one.
No, my friend's argument, I'm saying. My learned friend's argument. Come for the first time.
Yes.
In these proceedings. It's not even part of the grounds of appeal.
All right. Fine. Thank you. Mark everybody's presence. Arguments heard. Reserved for delivery of judgment.
Subject to your lordship's pleasure. Lord,
1 minute. One.
Yes.
1 minute. Stapler, madam. Send it to me. This file, this only thing, send it to me. Stapler. Keep it. along with these things.
Yes, 55 and Melot 56 may kindly be had on Monday instead of tomorrow. Tomorrow it's not. Only Melot, I am requesting for Monday instead of tomorrow. Item 55 and 56.
55.
5 and 56. Melot.
Yes. Who appears for respondent? 57.
I appear for the respondent.
That's what he's saying.
They made a target for the previous bench. They could not be completed. That's why they are before. I request your lordship to give priority. I request your lordship to give priority for this hearing of this batch. 55 to 57.
We did not say that we are adjourning. Your friend is the senior counsel. Madam, tell him that he is asking for Monday. It's not that we are not giving priority. That's why it has come up at.
I am ready today also. Only tomorrow's of income. That's the reason I am requesting for Monday.
Tell we are ready to accommodate. Your friend is opposing.
Only for Monday, my dear friend. Huh? Monday. Monday.
All right. I agree.
Because when it's you appear for Mr.
I appear for respond number 1.
But it's senior counsel.
Without subject to part third. Monday hearing subject to part third.
Subject to part third means?
Once we commence the hearing, secretary is to consider is a part third. So
we have not heard.
We have not heard.
We have not heard you. Where is the question of part third?
If any part
No part third. And we are sure that once we begin hearing, we begin hearing, you will conclude. You will conclude the same day on Monday, right?
Yes.
Mr. Senior Counsel, please ask your colleagues to prepare a synopsis and like this was done in this bunch. So it was easy. We could move faster. He had given us chronological events and written submissions. So,
I have already prepared. I have already prepared.
Senior Counsel for respondent number 1, place for short accommodation on account of personal difficulty. List on 14th August 23.
I have approached.
Yes. That's it. So your case continues.
On board.
Study circle. Study circle. Tomorrow we will continue with the study circle. So this part third matter is now concluded. So study circle, we will see where do you stand. Equal pay for equal work. Equal pay for equal work, right? Regular. Yes. So conclude fast, right? Within 5.
Mode of selection I made.
So conclude. You have an excellent case, so you must conclude within 10 minutes. We very often we will tell you the secret of judges, right? If first 5 minutes you are unable to convince the court, thereafter we only keep on hearing you. So any counsel who has an excellent case would conclude within 10 minutes. Thereafter, if he argues or he complicate like something, this thing, then 20 minutes. I would say half an hour.
I hope.
Beyond that, if you continue for hours, means presumption is subject to scrutiny that you have no case. So we are sure that you have an excellent case. So 10 minutes. Nothing, regularization and equal pay for equal work. He has to. Tomorrow. Yes, madam.
The matter referred to by my friend, my lord. Here the relief sought in the writ petition is regularization and
Whatever, we don't.
But already the services of the petitioners are terminated, and those are under challenge in different writ petitions, my lord. If your lordship pleases, I'll make my submission.
Please, tomorrow, please. We don't have the file also. We just began on that day.
Bringing it to your lordship's notice. Then.
The additional AG who was appearing short time.
Yes.
You remember if you are
yes, my lord.
If you are assisting in this short time, we heard him just saying like equal pay for equal work, and the other added that he is claiming regularization also. We don't know.
He's already terminated, my lord. That's all.
So
I'll update.
It's his appeal.
Yes.
Yes.
Obliged.